Yes, tell me.
Your Lordship. Your Lordship, I beg to mention item number 3, Your Lordship. Actually, senior advocate Visita sir was to appear, but he is not well today.
At the request of the learned counsel for the petitioner, appellant, the matter stands adjourned to be lifted after.
2 weeks, Your Lordship, after vacation.
Okay. We'll have it sometime in the month of May. In the third week of May.
Deeply.
Two matters may be listed after vacation, my lord. That is on 21st and another is on 22nd.
21st is Sunday.
For
21st is Sunday.
Monday, my lord, I'll change the date.
For what?
For hearing, these two matters are long pending, my lord. One is of 2018, my lord, and another is 2020. One is
Hearing matter?
appeal.
Hearing?
Yes, my lord. It came up in the my lord daily list for hearing.
I don't grant adjournment for hearing. I more mentioning for hearing. Sorry. Next.
Item number 16, my lord. Item number 16, my lord.
60.
16. Due to medical urgency, my lord. We have to take right to the matter. It is out of
16.
16.
Yes, what is it?
Add on the matter. Add on the matter. Therefore, add on the matter.
At the request of the appellant.
Lordship, we are the appellant.
I have
Will-
taken one.
We'll file one objection to their IA law.
I for what?
IA
I
for
for vacation of interim.
What is there to vacate? You don't want to do it, then I think you withdraw it.
Let come after.
Withdraw.
No.
Then there is no urgency.
My urgency, but
What is the urgency? You are asking for an adjournment.
yes, sir.
Then
It is medical urgency. But that is why I am saying
whose medical urgency?
because he is out of state.
Out of station.
Mine.
And his name nowhere appeared.
Yes, sir. I mean, here.
Okay. At the request of the learned counsel for the, you have objection?
yes, Lordship will file an objection to their IA.
Okay. Ms. So
Yes, they
appearing on behalf of the petitioner, appellant, submit that they want to file objection to the application seeking vacation of the interim order. 4 weeks time is left.
Lordship, date may be
Why?
May 6th of May.
Why? You have an interim order in your favor. Appeal has been admitted. So it will come in the month of in 2034. Why do you worry?
The first week of May, we have some difficulties. If it comes,
Absolutely no. You file. Leisurely file. Yes.
oblige, Lord.
And no, to be listed 4 weeks. The other side has no objection. Next.
Please, the Lordship, I like to mention item number 2 of the daily list. Lordship, this matter may kindly be taken up after review.
Why?
Lordship, some documents that
What documents are there?
Lordship,
On the
some
last
documents-
occasion, I was about to dismiss, and then I gave him a good chance that, okay, I won't be sitting out here. What documents are you going to do in an appeal? What are you going to do with an appeal? What documents are you going to give? Tell me. Your appeal arises out of a 34 application. Then, what documents? We will hear when the matter is reached. Next.
I recommend item number 25 on behalf of Mr. D.A. Kawam. He is out of state. He over telephone informed me to make a prayer on behalf
Item
of
number?
25, Lordship. He is at hometown due to this. He is tomorrow, Lordship.
Mr. Counsel, stay matters I don't grant it.
I'm not a counsel, Lordship.
No, then nobody appears. I'll dismiss for default. You
Lordship,
be there. You have taken the
I'm
responsibility.
not aware of the case, Lordship.
If the matter merits, whether he is there or not, I'll grant you an order. If the matter does not merit, whether he is there or not, I'll dismiss the matter. Don't worry. Next.
Item number 24.
Hmm.
Senior counsel Mr. Saibala would be appearing for all the response. We'll be filing our wakalat today. Immediately after it.
Why? Senior counsel has already been engaged.
No, my lord, all the respondents will be appearing tomorrow. Today.
You have filed the wakalatama.
No, today will be.
You know.
Well-
You know the matter.
No, my lord, yesterday night only they informed us and today morning would be received.
Okay, don't worry. We'll see whether his case is there or not.
My lord,
You don't appear, don't appear.
we had filed two affidavits, one by your lordship's direction regarding the Dutch service,
Oh, fantastic.
and another affidavit, my lord, there was an earlier order to bring on record the orders which were passed after passing of the interim order. So two affidavits.
No adjournment. You know now
So-
the matter. Get the file. If you don't have it, get a copy from. Yes.
I may be allowed to
Yes, yes, bring
get the
everything.
affidavit.
Yes, Mr. Sharma, what do you have to say?
My lord, I'll convince if my learned friend wants to argue.
Share with him. I am convinced with him.
Yes, your
You say.
my lord, this two section, in this proceedings, my lord, two sections are important. One is 31(5) of the Arbitration Consultation Act, and next section 47 of GPC. Now, my lord, what section 47, my lord, contemplates, my lord? Section 47, my lord, gives the power to civil court, my lord, regarding validity and legality of a decree in a limited way. It can, there is a chance to challenge the decree in a executing court also regarding some limited point. Say, suppose decree is an
No. It is not his case to that effect.
No,
Whether there is a decree or not.
I'm
No.
coming to it, my lord.
Mr. Sharma, kindly appreciate. Whether it is a decree or not, that is the question at all.
That's why, my lord, your
In view
lordship,
of the termination, it would be a termination of the proceeding only after a copy is served to him.
Yes.
Unless you show before the trial court, before the executing court, that you have served the copy upon him, or by have taken steps under section 3(2), then only the court should
now
have
the question
proceeded.
that I'm coming to that, my lord.
Hmm.
Regarding, my lord, service of that copy, that receipt of the copy, my lord, that I cannot say, that arbitrator will have to say.
Absolutely.
That in the executing court, there is no chance to, my lord, the arbitrator show, my lord, because the records of the arbitrator is not called for. Now, in this case, your lordship, if 47 is, my lord, is allowed, that my execution proceeding will be dismissed, and I'll be debarred to, my lord, file execution process.
No. Mr.
And this, my
Sharma,
lord, at least he can.
Mr. Sharma, that thing is not going to happen. They have raised the plea that they have not received.
Yes, your lordship.
Now it is for the executing court out there to see as to whether it has been served or not.
Arbitrator.
Listen,
yes,
listen, don't jump to conclusion. So for that, what is required is the arbitrator has to be asked as to whether the copy has been served. Now, who has the records?
Arbitrator has the record.
So arbitrator will have the records.
Yes,
So
Your Honor.
you have to contact the arbitrator. You have appointed whoever has appointed the arbitrator. He has to go and show that records. This is how it is to be done.
My lord, from the arbitrator.
Because he can't prove a
Yes,
negative
my
thing.
lord, executing court, if executing court, my lord, calls for the record, we have no problem. Because now the
That is
question is
what-
that whether
Mr.
executing has
Mr.
power to
Sharma,
call for the record.
That is what the executing court is required to do.
Yes,
Now, I am not setting aside the entire execution proceedings. No,
yes,
I am rendering the proceedings back to the executing court so that this question is being decided.
highly obliged,
That's it.
highly obliged.
Have you
Because
seen
of
my
the record-
judgment in Mukul,
Yeah.
Kolita and all? Give it to him.
Yes, I know that, I have read.
In that judgment, what I did I set aside the entire proceedings?
No,
No.
No.
I kept it, giving them the opportunity to the decree holder or the person who has got the award in his favor to produce before the court whatever service of summons have been made,
Yes.
and thereupon to continue, because he cannot prove a negative aspect. That
Yes.
is his only question.
And my lord, off the record, because I cannot show it, that we were told that they have received a copy.
Understood. So whatever may be,
Yes,
you
Your
have
Lord.
to give
That clears, your lord.
a small
That will
piece
be
of
happy.
evidence. Give me that order. देखो, This is an application. You filed a 47.
Yes, sir. 47.
47.
This is an application under section 115 of the Code of Civil Procedure 1908 challenging the order dated 17/4/2015 in money execution case number 59 of 2013 passed by the additional district judge number 3 Kamrup at Guwahati. From the perusal of the materials on record, it reveals that an arbitration proceeding had taken place between the
Petitioners and respondents.
petitioners and the respondents, between the respondent and the petitioners.
Yes.
It is your reference.
Yes, I am doing.
Pursuant thereto, an arbitration award was passed on 25/4/2011, whereby the petitioners who suffered the award was directed to pay certain amounts along with interest. Pursuant to the said award, the respondent in whose favor the award was passed filed an application under Section 36 of the Arbitration and Conciliation Act 1996, for short the Act of 1996, for enforcement of the said award, taking into account that by virtue of the said provision, the award becomes a decree of the court. Upon receipt of the said award, upon receipt of the said application, an objection was filed on the question of by challenging the executability of the decree on various grounds, including the ground that the signed copy of the award was not delivered to the petitioners. Yes, where is my judgment?
My lord, actually, I put qualify type at the library, but that judgment I could not find. And I don't think it is, my lord.
One can help you, but can't help you so much.
But actually, I tried my best. Actually, one Mukut Kolita State of Assam of 2009 passed by CRP number 71 of 2020. Order dated 27.
Saying, Mr. Counsel, you need to buckle up. This is not how you do matters before the court.
It's not public. I checked the app at the library. I think it is not public.
Is it?
Whatever to is DR APCL.
It is reported in 2022 6 GLR 450. It is reported in 2022.
What called was a HDFC Bank.
It is also reported in 2022 4 GLT 802. And then also you don't. But then I think the only thing that can happen, help you is you need to do proper puja during the Durga Puja festival. That's- yeah. The objection, this court have duly heard Mr. So and so and so and so, the learned counsel, Mr. So and so, the learned counsel for the petitioner, Mr. S. Deka appearing on as an amicus, and Mr. M. Chaudhary, M. Sharma appearing on behalf of the respondent. And given the due consideration to their respective submissions. Amongst the various objections which have been taken, the objection as regards the award having not been delivered to the respondent, to the petitioner herein, is an objection which touches on the maintainability of the execution proceedings. Inasmuch as it is well settled that the delivery of an arbitral award under subsection 5 of section 31 of the Act of 1996 is not a matter of mere formality. It is a matter of substance, inasmuch as it is only after the stage under section 31 had passed that the stage of termination of the arbitral proceedings within the meaning of section 32 of the Act arises. The delivery of the arbitral award to the party, comma, to be effective, comma, has to be, inverted comma, received, inverted comma, close, by the party. It is also very pertinent to take note of that the delivery of by the arbitral tribunal and the receipt by the party of the award sets in motion several periods of limitation, such as an application for correction and interpretation of an award within 30 days. Under section 33(1), comma, an application for making an additional award under section 33(4), and an application for setting aside an award under section 33(4)(3), and so on. Under such circumstances, this delivery of the copy of the award has the effect of conferring certain rights on the party, as also bringing to an end the right to exercise those rights on expiry of the prescribed period of limitation, which would be calculated from that day, comma, the delivery of the copy of the award by the tribunal and the receipt thereof by each party constitutes an important stage in the arbitral proceeding. In a recent judgment of the Supreme Court in the case of Dakshin Haryana Bijli Vitran Nigam Limited versus Navigan Technologies P Limited, reported in 2021 7 SCC 657. The Supreme Court in paragraph number 34 to 36 held the date on which the signed award is provided to the parties is the crucial date in the arbitration proceeding under the Act of 1996. It was further observed that it is only from the said date, the period of 30 days for filing an application under Section 33 for correction and interpretation of the award or additional award can be filed, semicolon. The arbitral proceeding would terminate as per provided under Section 32(1) of the Act of 1996, and the period of limitation for filing objections to the award under Section 34 would commence. Paragraph 34 to 36 of the said judgment is reproduced hereunder. In the backdrop of the above, if this court takes note of the impugned order, it would be seen that the learned executing court, that is the court of the additional district judge, what is that court?
Number three. Additional district judge number 3.
Additional district judge number three
Number 3.
Kamrup at Guwahati.
Kamrup Metro.
Kamrup Metro at Guwahati did not take into consideration this very aspect of the matter while passing the impugned order dated 17/4/2015. This very aspect of the matter ought to have been taken into consideration by the said executing court. More so taking into consideration that an arbitration proceedings only terminates after the award is delivered in terms with Section 31(5) of the Act of 1996. Under such circumstances, this court interferes with the order dated 17/5/2015. This court further directs the learned additional district judge number 3 Kamrup Metro at Guwahati to take up the said execution proceedings as well as the Section 47 proceedings filed by the petitioners herein, and decide as to and adjudicate as to whether the copy of the award have been duly served upon the petitioner oblique the judgment debtor in the said proceeding. This court grants the liberty to the decree holder, that is the respondent herein, to place such materials which would otherwise show that the copy of the award have been duly delivered to the petitioners oblique decree holder, judgment debtors. Taking into account that there was a stay granted by this court on 28/4/2017, the stay order stands vacated, and the parties being duly represented are directed to appear before the learned executing or the learned court of the additional district judge number 3 Kamrup Metro at Guwahati on, let's have an unlucky day, 13th of May. 13th of
Well, his one petition is order dated 13/5.
Hey,
It's not
record has been
13/5,
called, na?
17. It's not 17.
Okay, 13th.
17/4.
The records which have been called for by this court is also directed to be transmitted back to the court below by the registrar forfeit for that purpose, and forfeit so that on the next date so fixed, the said court is in a position to take up the matter. The registry shall also employ the services of a special messenger for transmission of the same.
My lord, my lord, it is not 75, 74, my lord, ordered in it.
For 17.4.
74. And
Oh, now you have read it properly.
Yes, yes, Your Lordship.
Now tell me what is your case.
Your Lordship, on previous days, you have asked me to.
I
provide the
asked
cor-
you not once, why? You are not.
Uh,
Now let's see whether you are prepared.
Asked me to
What are
provide
you
the correct
challenging?
address of the parties.
What are you
respondent.
challenging? Huh?
Correct address of the respondent.
Then?
And the address given in the petition was the correct address. Is the correct address of
The correct address.
Your Lordship.
Now what happened? I remember your case. Your case was that this written statement was not taken. The
Yes,
other
Your Lordship.
side's case is that, look here, so many times, even during that period out there, you were served out there in that particular family court.
Yes, Your Lordship.
Then also you didn't do anything.
No, in that time, that was the COVID period, Your Honor.
So,
Lodge. And no one is allowed to go to the office room or courtroom. So how can engaged counsel will appear on behalf of the petitioner?
but during that very COVID period, they gave it to you when you were in the court.
I don't know how they do that.
Huh? Tell me, which order you are challenging?
You're the expert secretary.
Where is the order? 11/12/2023.
Yes, yes, Your Lord.
What has happened now? I asked you. What is the next stage? What happened on 11/3/2024?
15/5
For what?
for PW cross.
So it has already been, PW has already been given.
Yes,
Then?
Your Lord.
And you were supposed to file this on when? 2021.
Yes.
It is a matrimonial dispute.
Yes, Your Lord.
What dispute is this?
Your Lordship, the respondent married the petitioner long ago, but after few days he driven out her, and thereafter she filed a maintenance case before the family court Guwahati, and the petitioner was allowed for a monthly maintenance from Your Honor, what's it? From 35/1997.
No. Why is this? What is this case for? Title suit number 131 is for what?
He asked to he asked the
What is the claim for?
ejectment declaration and realization of damage
Ah,
and compensation.
suit for ejectment, declaration, realization of damage and compensation. Oh, he says that he is not your wife, husband,
Yes, Your Honor.
and you are residing in his place. Then?
He is Your Lordship, he is paying maintenance from a long time, and recently he no, and he filed several cases against the petitioner
Solution notice.
in family court, and all
Notice
all that
making
cases
it
are
returnable on arbitration notice making it returnable on, what is the next date?
15/5 year.
15/5. Issue notice making it returnable on 10/5/2024. The petitioner is directed to take steps by way of registered as well as judicial. In addition to that, the petitioner is directed to take steps by trustee routed through the registry of this court and file an affidavit of service on of the court and next. This is an application filed challenging the order dated 13/12/2023, whereby the application filed by the petitioner to be permitted to file the written statement was rejected. The learned counsel appearing on behalf of the petitioner submitted that the written statement is ready and can be filed on any date. It is the further case of the petitioners that on account of the fact that she being a simple lady and having not understood the effect of receipt of the summons, did not take appropriate steps at the right time. This court have also perused the claim wherein various serious allegations have been made which would affect, and any decision in the said suit ex parte may affect the rights of the petitioner in other proceedings which are pending. Considering the above, this court stays the further proceedings of title suit number 131/2023 pending before the Court of the Civil Judge, Senior Division number 2, Kamrup Metro at Guwahati, till the next date. But if you don't take service by way of the stay, I have the habit of vacating and dismissing. Do this. Yes, what is this?
Lordship, this revision petition is directed against the order dated 12/1/2024, passed in title execution 1/2021, dismissing my execution proceeding on the ground of non-executability. In spite of the fact that trial court as well as appellate court upheld the decree. On the basis of a report filed by the
unexecutable. Why?
this is boundary did not match with that suit land by the report filed by the that bundle revenue.
Where was this?
It was before the trial court junior division, civil judge junior division, Mangalore.
Did they object to the boundary? In the suit?
No, they says subsequently they says it is a government land. During the proceeding, they never said that is not. They admitted that they are under our tenant. It's a private land. Subsequently, in the objections in the execution proceeding, they said it is a government land.
No,
But-
no, as per your document,
Lordship.
are you the owner of the land?
Yes, I have.
So if it is you are the owner, you have got the land. By how did you get the land?
There was an agreement.
How do you own a land on the
Own the
basis of
land
an
on the basis
agreement?
of patta. I have the patta.
You have a patta.
Patta.
Okay. Now the patta has four bound. The patta is contain only one dag.
That patta contains one tag, that lag number 519, patta number 73.
Okay.
And there is, to that effect, there is no dispute. Even there is not raised any
No, no, your land
Yes.
is in a dag number, a particular dag number.
particular.
a
Type one.
particular dag number which has only one patta number.
One pattern,
In one patta, there is only one dag.
one type.
So obviously it will have four boundaries.
Lordship, only thing, out of the schedule two, which is within the schedule one, actually that while giving the boundary, in the western side boundary, that when the western side, my remaining part of the 519 tag falls, thereafter road comes. But instead of giving the road, instead of giving the my own land, I have given the, what is that called, public road as a prescription in my plane. That is why, and there are minor.
Now what do you want to put?
I want to say that it can be identified.
What do you want to put now on the western side?
By amendment, they says
You
that
filed an application under 151.
151, 153.
What is
That was
this
the-
151, 153 in an execution proceeding?
It should have been 152, otherwise 47.
It should have been a 47.
Or 47 or 152 also will do. Correction amendment.
152, who will do?
152, even as an executor, as an.
Absolutely no.
that the ruling-
152 is for the court to do.
Yes, Lord.
You are referring to Pratibha Singh.
No, Lord.
So there it categorically say
yes,
152 is for the trial court.
Trial court.
But this thing can be done by
Yes. By
what you call
47
under
of the
47.
47 of the.
Yeah.
Right. So there it is Pratibha Singh, there is clear. So by, we may be allowed that, but there is court may be there,
Anyway.
court may be directed to.
We have to issue notice only.
Lordship.
You want an early disposal?
So let them, if the court decides it, then
Okay, you don't want. We'll have it after 6 months. Issue notice making it returnable after 6 weeks. The petitioner is direct take steps by way of registered as well as usual upon the respondents. Steps be taken within 3 days.
Please, your lordship. But the petitioner hearing their plaintiffs, the suit was decreed in their favor in 2015, and thereafter title appeal was filed by the defendants, who are the respondents here. And since 2015, the title appeal was admitted, the stay was there, and since today, it is pending on this or that pretext. So what we are praying here is for a time-bound disposal.
Huh?
For some time-bound disposal. 9 years it is pending.
Where?
It is
When was the appeal filed?
but the appeal was filed on 19/12/2015. It was admitted 19/12/2015,
Then
and
did you file an application before that court? They kindly do it. We are suffering. No. Then why should this court entertain all these things?
Lordship will see one thing that 2020, the first appellant had expired, and thereafter they did not even inform the court. And we in 2021,
You are the respondent.
we are the respondent in the appeal.
Hmm.
And thereafter in 2021, we had informed. And thereafter also, till today, although they have filed substitution after 1.5 years, after our information, after we have given information to the court, till today it is pending, and thereafter, along with the substitution petition, they did not file setting aside abatement. On the last occasion, they have filed that. Next date is again fixed for that, and thereafter, some order sheet we have annexed. But people see how again and again time was taken, and
No. Withdraw. I'm passing direct. The instant application has been filed under Article 227 of the Constitution, drawing to the attention of this court that title appeal number 7/2015 pending before the court of the additional district judge FTC Dorog Mongoldoy have been pending since 2015, thereby causing great prejudice to the and pending since 2015, and on account of the delay in disposal of the said appeal, great prejudice has been caused to the petitioners, who are the respondents in the said proceedings. The entire contentions, the entire gamut of the petition is on the basis that the respondent herein, who are the appellants, have been dragging the said appeal by virtue of taking a stay to the execution of the decree, the stay of the
judgment.
of the judgment and decree passed by the trial court. So this court had put a specific question of query upon the learned counsel appearing on behalf of the petitioner as to whether such an application has been filed before the learned trial court, first appellate court. The learned counsel, with all fairness, submitted that such application has not been filed. So it is the opinion of this court that such an application is required to be filed by the petitioner. And it is the opinion of this court that if such an application is filed before the learned first appellate court, the first appellate court would have considered the said aspect of the matter and expedited the disposal of the said appeal. Having not found filed in such, this court is not inclined to entertain the instant petition. However, this court makes it clear that the petitioner herein would be at liberty to file an appropriate application before the learned first appellate court, apprising the court about the delay and on account of the delay, the prejudice which has been caused to the petitioner. This court requests the learned first appellate court, that is the court of the additional district judge, FTC Dorong, Mongoldoy, to upon such an application being filed, to expedite the disposal of the said appeal, inasmuch as the said appeal has been pending almost for a decade. With above the instant instance closed.
Obliged.
Because if I issue notice, nothing
No,
is
no,
going
yes,
to happen.
And
This is the only order which will help you.
Yes. but to
Why? I gave you so much time last time.
No, I received all my lot, but I have to, some document yet to be received, some bulk petition I have received my lot, and I have to file it my lot in the way of.
What is there to file?
No, my lot, your lot.
You are challenging an order passed under 34.
Okay.
So when you are challenging an order passed under 34, this court is only to look as to whether 34 proceedings was rightly done or not, within the contours of the powers under 34.
So 34, my lot,
What documents should I look in?
last time my lot, your lot. Any time that time,
I
my
gave you that time only because of the time to escape from this bench.
lot. No,
But as ill luck has had it, this court again is sitting in this bench.
no, they have not that, my lot. Your lordship kindly accommodate.
I made it very clear on the last occasion, isn't it, Mr. Bull? I made it very clear
Your
that he
lordship-
will escape,
your
that
lordship
I may
kindly-
not be
kindly
sitting out
give me
here in
some
the month
time,
of
my lot, because
April. But the sad part is again I am here,
some
and you can't escape the rigors of this court till to May. So
my
the
lord,
problem
I
happens.
satisfy your lordship. If this time I satisfy your lordship. In
Huh?
appeal, my lord, I'll just satisfy your lordship and give it.
No, the main problem which arises in your appeal is this. First of all, who are you? You have no business.
No, my lord, I have given a application. That on that application, just to say that other village, the executed a nearby village, same paper should be given to me. And that was sent to my lord arbitrator. I am not paying for send it to arbitrator. Ultimately, I have to bound to enter it, my lord. I file a application before the deputy commissioner that I am also affected and my nearby village, as I have given to the other villages, my lord, that same should be given to me,
The rate.
my lord,
The rate.
my lord,
The rate of the land.
my lord, rate of the land. So, my lord, what happened? My lord?
Obviously, it is the arbitrator who can do it.
So that's why he send it to my lord arbitrator.
Rightly.
So send it to my lord. That's why I'm entering, my lord. And they, without giving other notice to the others, my lord, that has been decided against me, my lord, or against me in a wrong, wrong, my lord, wrong.
First of all, are you the owner of any land?
Yes, I'm a owner of the land. That yes, we have received the TZ notice, my lord. We have received the amount, enhancement amount, my
No,
lord.
you can only file for yourself. What is this executive
No,
president
my
of
lord, in
four
my
lane
that- in my
affected
that application, my
demand?
lord, to-
This is an unregistered body.
Yes, my lord.
This is not a writ.
No, that is,
Then
your lordship, no, that, my lord, I'll find out some judgment, my lord, that can be, my lord. Yes,
which
there is
one?
judgment of the Supreme Court, my lord, in the representative capacity, my lord. The same allegation, my lord, that can be done. There is a judgment,
Representative capacity?
my lord,
Supreme Court says.
my lord, there is judgment.
Where?
There is AI 1990 Supreme Court 6-4.
In what matter?
That is also, my lord, some payment of money in the society.
What money?
That the acquisition.
Acquisition, a person can file under representative capacity. Let's see what the.
No, here is the arbitrator, my lord. Your lordship kindly state
That is
my-
the problem,
That is
Mr.
the
Mr. Counsel.
lord.
Kindly appreciate. Because of you, others will be harmed. That is the reason why I'm
No, my lord,
drawing you out.
your lordship kindly see now, my lord.
Moment you are doing it for others, others' rights we are also affected.
Exactly, my lord. That has to be looked into by the, my lord, by arbitrator, my lord. My lord,
Yes.
arbitrator, what happened, my lord? I file a petition to the deputy commissioner.
That is what that is how the reference is made. The reference is made under
that-
3C5 on the basis you filed
But
that.
that is
Look here, I am entitled to
Yes.
this amount.
I agree, my lord. But after getting that, my lord, deputy commissioner, when he send it to the arbitrator, my lord, arbitrator should have send a notice to the, all the parties. That is not been done, my.
All the parties are not before this court.
But
But do you have the right to do
no,
so?
that in case of me, my lord, along with me, my lord, I am also one of the affected, my.
So you were there.
So I am there, my lord.
You appear before the arbitrator.
But I appear before
Then
the arbitrator, my lord. So,
what
my
is
lord,
wrong?
arbitrator, my lord, wrongly, my lord, calculated. That's why I am submitting, my lord.
No, if it is a wrong calculation, would it be an interferable under 34?
But not even the 34, my lord, dismissed, my lord, on the ground.
Understood. Can it be interfered under 34 if it is wrong calculation? No. That is the problem. 34, you cannot. If there is a wrong calculation, you cannot.
No,
You can very
in
well.
wrong calculation, they have taken a document, my lord, taken into account. Since your I am in village, my lord. But since your town committee is declared in the year 2015, that so you are not entitled to get the royal committee. That multiplier question. So that which was produced by deputy commissioner, your lordship kindly see that, my lord.
Where? Where the award?
Award at my lord, page 22, my lord. Page, your lordship straightway goes to my lord, last para of the page 22, my lord. Last para of the page 22. Last 14.
Page 25. Who are you? Affected of land acquisition, NH 37 land acquisition affected people's demand committee
Right.
has also claimed interest. So they say that you are entitled from 1.5 to 2.
No, we are, yes, they say that we are not entitled.
No, it says kindly see 25. I have carefully perused the said provision and also the other clauses of the Act and notifications of the Government of Assam. In view of the state guidelines of the central government, the multiplication factor would be applicable 1.5 to 2 in respect of Jorhat district, and also depending upon the distance of the project from the urban area, excluding the area already notified in the urban area.
But our claim is already rejected by not para 20, page 23.
Page
Page 23, last portion.
23.
Page 20, first para, last part. Page 23, my lord.
Yes.
Last part, 4 line of the first para, my lord. DC Jorhat submitted this device thesis estimate excluding the Tiok town committee area, as the Tiok town committee area is considered as an urban area which has been informed by government of government of Assam letter dated 2016, and those multiplication factor of 1.5 or 2 cannot be applied in case of the Tiok town.
Now this is whereas. This is not the decision, it is whereas.
My lord.
Kindly come, this is whereas.
My lord.
We are not on that. Now let us see here. Where is the finding that there is an urban area? That this the petitioner's case is the falls on the urban area. Kindly see, whereas so affected human has also claimed interest on the so the payment of the first calculated compensation, the payment of the so in view of the delay, deposit of delay in payment of the the affected parties for its money that extra compensation expenses according the and state where is the finding to the effect that you are
But it was not granted to me, my lord. We filed appeal against that, my lord.
Huh?
My lord, finally seen appeal para 16, my lord.
appeal? What appeal?
That is 34 appeal. That is your lordship, which I will
Sir, Mr. Mohanto, kindly don't say that to
No.
be an appeal. It's
No.
an application.
No, that is your lordship, that is award.
Appeal is I am sitting.
My lord. Yes, no, that is yes, sorry, my lord, it's 34, my lord. Now
Yes.
there is 37, my lord.
Now we are in 30.
Yes, no, your lordship kindly see that order passed under section 34, my lord.
Where is the order?
Para 16, my lord. Page 50.
So the arbitrator has discussed as to how initially the estimates were prepared putting the factor of Mr. Borua, can you come to page 57?
Page parameter.
Page 57. The last 7 lines of
Learned
above para 17.
Last learned
The learned arbitrator has stated in the said estimate that the Theo committee area was excluded because the same was considered as an urban area which was informed as so and so, and as such the multiplication factor cannot be applied. Now, where is the finding of the learned arbitrator for this?
regarding them. Petition. Petition.
This,
Appellant.
this finding, because when you are discussing whereas, it is not what you are stating. The finding will be after whereas
Yes.
is over.
As already discussed, put under section 20 cannot be appealed. Not sole arbitrator while affirming the stipulation of malvision.
Now, whether that you fall under the Theo committee,
Yes, Tiok revenue circle.
then
Now, my lord. But that is a, my lord, 2009, my lord. Notice was 2009. Market value has to be decided in 2009, my lord. That's for section.
then market value as per 2009.
My lord, because notification was 2009.
How is it in 2009? Then you will come within the ambit of this.
My lord. No, payment was made in 2015, my lord.
How does it make any difference? Payment made
But,
in
but
2000.
on the basis of that, my lord, others were given the other nearby area was in 2015. That has been
No,
paid.
if the 2009, it has already been award has been passed.
No, the award has been not passed in 2000.
When was the award passed?
Award passed, my lord? That is this award.
What was on? That is on.
Award passed on, my lord. It's 10th October 2018, my lord.
18. So obviously then they will come within it. Now if that be so, then as on that date, Whether it was under this, the Theok Revenue Circle, this thing, the Theok Town Committee, did you fall within the Theok Town Committee?
My lord.
Then-
No, your lordship can see that order of my lord that the compensation will be, market value will be determined at the time, when the notice was issued. Notice of your lordship can.
Understood. Next,
So-
notice
so-
under section 3,
My lord,
3A.
TA. That was issued in 2000, my lord, 9.
Then,
Now, my lord, applying the same, my lord, in my nearby villages, given my lord, multiply as 1.5 to 1.2, my lord.
Uh.
So in case of me, my lord, as it is.
but you come within the Theok committee.
No, at that time, I'm not come, my lord. Now, my lord, I come.
Understood. At that point of time, you were lucky enough then also to get more compensation
No.
now.
Getting less, my lord.
You are now getting 100% solution.
No, my.
Yes.
No. That is not my case, my. I-
Understood. You want the multiplication factor,
Yes,
which is given in 26.2.
my lord.
That I understand. There's no quarrel with that. But the fact is, you have got now the solution of 100%. If that payment would have been made earlier, you wouldn't have got anything till 2015.
Okay, 14 inches.
No, not 14. For
15,
National Highway, it is 15.
15, 15, 15.
Till 15, any payment would have been
No,
made,
now
you would
my
have
lord-
not even given 100% solution. You have already got the double.
No, my. I am not getting the table, my lord. That's why.
And more particularly, are you not getting the interest from 3A? You are getting 12%.
No, my lord, my only advantage is that the multiplication, my lord.
Obviously, at that point of time, it was not. That fell within the Theok Revenue Circle. The town committee, urban area.
No, that is the town.
When the competition is made,
Town committee, my lord, that is declared later on. Before that, that is mean, my lord, already, my lord, in case of other efforts of that, the compensation has been, my lord, already determined, my lord. Compensation, my lord, I want that I may be treated as a rural area depending upon the distance, my lord.
but as on the date on which your compensation is being taken up, at that point of time, you were not a rural area.
At the time of giving the money, my lord.
No, at the time when the award was passed. I'm not saying about giving the money. At the time when the award was passed.
Award was passed in 2018, my lord.
So at
So
that
that is
point
my
of
lord.
time, it was not a rural area.
My lord, that is not a rural.
So when it was not a rural area, you will be only entitled to whatever the multiplication will be only one.
No, my.
Yeah.
That's why, my lord, in respect of other, they have given, my lord. I not
Others,
me.
whatever they do,
No, my lord, your lord.
that is the only good part about this thing. In an arbitration appeal, we have to kind of shut our eyes to everything else. There is a committee. Your basic, I understand what is your case. Your case is, look here, in 2009, when the notification under 3A came, mine was in an urban area. And as I was at the urban area, you have taken the value of the land as an urban area. And I was in a rural area, and you have taken the value as a rural area. Now, why now you are giving me compensation on the basis that it is a rural area, but not applying the multiplication factor?
No, multiplication factor, my lord, it is taken. Yeah, the time of payment, my lord, it should be taken in a village area, the rural area. That is true, my lord. I am not on there. But multiply, my lord, rural area getting more, my lord. Comparison to distance of the money, it is, my lord, within 10 kilometers from the town committee, my lord, town area, then they will get, my lord, multiply with 1.5. If it is above 10, my lord, that will get to 2, my lord. So that, my lord, I am submitting that on, that is a myth. Because Deputy Commissioner says they already declared town committee, you are not there. But in respect of other villages, has been given, my lord. But my submission before your lordship that at that point of time, in 2009, that we are in rural area, and that
Understood. That is what I'm saying. That is your argument. Your
Right.
argument is, look here, in 2009, as I was a rural area. You are giving me compensation on the basis of the notification issued under 3A.
my lord,
That is on that date. The value is taken as on that date. At that point of time, I was in a rural area. Now, while you are giving my compensation giving me the compensation, I may have fallen in the urban area, but the compensation which you have taken is as a rural area for which you apply the multiplication factor
but my-
and
my-
thereby
my case
give me
multiplication is not
more.
been applicable. So that is, multiply is not been applicable in my case. They have not done it because they says that this is not. They cannot give retrospective effect, my lord. That is my lord, my. So let the my lord accordingly call for your lordship and examine the matter, my lord, because these 12 villages are my lord, they are my lord.
They are in urban area now. They no longer
no,
rural
no.
villagers. As of now to 2018, they
Yes,
are
my lord,
rural,
yes,
yeah.
ultimately, urban area, my lord.
Then
If they paid me urban area, then my lord, I'll be happy. I'll getting more, my lord. They neither pay me, my lord, rural area compensation, nor pay me, my lord, market value urban area. If they give me market value of urban area, then I'll be happy, my lord. I'll getting more, my lord. Only on that multiplication factor, that has to be examined, my.
no, that is an examination to be done in a writ, which I would have very happily done, but not in an arbitration appeal. You have to understand that. There's a difference between this.
But already
This
they-
contours is very less.
No, my lord.
There might be many mistakes out there,
My lord.
be committed by the arbitrator. Can't help it.
Supreme Court judgment has come and related.
So many judgments. Your
Let me-
argument which you are making looks fantastic for a writ petition,
Then,
not
my lord,
for
I
this.
may be giving a liberty to file a writ petition.
What? For this,
No, my lord.
I should not give you the liberty. I will give it somebody else to file. That is why I had the problem with you being the committee member and all. You filing this has made a problem for these people. That is why I don't want you. Why at the first point I'm saying that this executive president of the 4-lane affected families demand committee, if you are putting it, you will have a problem for all other people who are there. You want to fall down from the ship, fall down, but you want to drown the ship
For that,
with
my
all
lord,
the
they-
people.
No, until and unless that 37, that 34 judgment has gone, my lord. I cannot, my lord, agitate.
You can't hesitate, but others, that is why. First of all, whether you had the authority, better therefore I say, don't bring the documents. The moment you bring the documents, you are putting others also, you are drowning the other people.
Give me some time, my lord. I'll satisfy your lordship, my lord,
Okay.
because-
Again, another adjournment on the ground of
No,
documents.
that, no, not.
Because it
document, my
looks
lord.
otherwise, what is there to
No,
grant?
my lord. Is a-
If I say that I have heard him, then the matter will again come back to me. There's a
no,
likelihood in the month of May I may not sit.
I will satisfy your lordship.
No, I'm not satisfied. You can't because
Because
30, this is 37, it's very
I understand,
limited.
my lord. Substitute question of law is not required, but I have to satisfy your lordship.
So
yes.
you have a problem, take it. But don't drown the other people. The only thing what is required is to challenge that notification.
No,
That notification by which they have made it that
I
they
can
walk.
easily file a petition in aspect of the others, my. But that moment come, my lord, yes, or that they will take a decision, that they will make a submission that, well, you have already filed a bill because his application was forwarded to the arbitrator, which I represented, my lord.
His application was, your application was forwarded,
My
not the,
app- yes.
not the
My
others,
application, my lord, yes.
not the others.
No, there are four other,
So 4 others are not before the court.
my lord, application also there, my.
So there was there any decision being made by the arbitrator?
Same point, my lord, that is exactly.
Because the arbitrator can't do it in this
No,
manner.
since
What
my
they have
lord,
done is
already,
you have rendered the arbitration proceedings into a nuisance. It is not the manner in which you do the arbitration. Did you ever hear them?
My lord.
Did the arbitrator at all hear them? Call them. Look here, what do you have to say?
enough,
That part I.
enough.
Yeah, it is just a formality.
Lordship same because Lordship is rightly pointed out similar. So many cases have been dealt by your Lordship path and any petition. Here again problem will come because here he has only filed. No other person if you go by only graduate amendment president as executive president. First question. Second question,
I'll do one thing. This is an appeal filed under Section 37 of the Arbitration and Conciliation Act challenging the award, challenging the order dated 4/12/2023, passed in arbitration matter number 1/2023 by the Court of the District Judge at Jorhat. On 13/3/2024, this court permitted the learned counsel appearing on behalf of the appellant to produce documents to show that the appellant herein was duly authorized by the Four-Lane Affected Family Demand Committee. However, the appellant failed to produce any such documents. Under such circumstances, this appeal shall be only constricted to the appellant and not in any manner touch the Four-Lane Affected Family Demand Committee. Mr. T.J. Mohanto, the learned senior counsel, seeks for a further adjournment. Please in the month of May. This is how I take you out from. Eh? Do something. You need to challenge that notification. Not the award. Don't challenge the award. Award, if you challenge, you go.
Good.
You are in more trouble.
Yes, sir.
You challenge that notification by which it has been made to you and the action of the authority, the DC, to take it, to give it that this is it. Although the land was valued at so and so. That is the only way out. But your appeal is to be dismissed.
I am paying for respondents 4 and 5.
And I have not considered anything. I have not disturbed other people's appeal. Appeal notice has not been issued. Appeal has not been appealed. His locus is itself. Next. What is this? Such an old matter. Oh, this is my matter. No way, no. I'm not there.
No.
Tell me.
On 9/1/23, there is a bill stop.
You are a ICICI bank.
Yes, yes.
What has happened?
The WS was filed on time. After that, we filed a petition to vacate the ex parte order along with WS. But the learned trial court has rejected our petition.
Which order?
Sorry,
Which order you are challenging?
page 62.
Plaintiff and defendant are presented, already heard both the counts sides on petition filed by the defendant for vacating the order by which the suit was directed to proceed ex parte against them. The rules appear, I may note that what is that order of 1/5? Where is 1/5?
Page 39.
Provision
Annex
of
of-
claims are not expected. Also, there section 5. The suit is primarily for the proceed of defendant received a summons on Iman and they have filed their protest along with their joint written statement. Therefore, there was a clear delay of 38 days in filing. Even the period provided. Reason assigned for the okay. We allow it subject to cost. Your ICICI bank, 25 lakhs. ICICI bank, you've got a lot of money. You're the
Money is involved is the
what public
the
money?
bank
Public
has
money is
by-
there, but the amount of interest you get, interest is enough.
by depositing fake gold has taken loan of 2 crores. So in respect, FI was lost against the plaintiff.
You did not file a suit or did not do anything. Then why didn't you file it within time? If you have official problems, then check out the official problems. Pay cost.
I give the explanation on para 6.
No, ICICI bank is a big corporation. 50,000 is minimum.
The lost it
50,000.
120 days.
20, no, every day it is 1,500 rupees. For 38 days, how much? isn't it? Man? And pay it to the
On,
other side is not there, so pay it to the welfare advocate welfare.
on 128 days, I filed a petition along with the WS. I filed.
What?
After that, I filed a petition along with the WS.
You have admitted that on account of official problems you did not.
The entire due to half-heartedly closing, he did not inform the concerned office.
So what? How does it matter?
I've been all the explanation in paragraph number 6.
I'll allow it 50,000 cost.
What?
Some cost has to be given. Otherwise, it will portray a very sorry image. The other side, the judges, and further to that, you got to stay. You have delayed the suit for last 9 years. So it has to be 50,000 plus another 9 years into 45,000.
128 days immediately you filed the WS.
Understood. You got a delay. You have delayed the suit. That person must have got frustrated because of
he was arrested by the police because of giving fake gold to the bank.
This is a suit of 2015. It is still in the stage of written statement.
In the plea also he has admitted that he was arrested. We have lost an FIR to the police. He was arrested. In the plea also he was mentioned that he was arrested.
So what? Because of that, you have even harassed him and put him behind bars. Also.
Giving fake loan.
No, has the FR been filed? Charge sheet been filed? No. It's only an allegation. You are appearing, Mr. Counsel, in this matter?
Lordship.
Huh? We allow his application subject to deposit of 25,000 as cost plus another 45,000 on account of delay. 60?
There's so many respondents. So the topic was not such earlier. So
We are not concerned with you. We are only concerned with you. Otherwise, why will the trial court say that, okay, order 8 rule 1, if I dismiss it today or reject it tomorrow, they will go and get an order from the High Court. High Court will allow it. What is this? No. This is an application. All these are plaintiff. You are paying for all the respondents. How many?
Lordship, I'm appearing for 3, 4, 5, 6, 7.
Service is otherwise complete, I
yes,
suppose.
only in respect of restaurant number 17. Who
What
was
has
the
happened?
erstwhile manager of ICICI Bank. He left the company a long time back. So only in respect of restaurant 17. He was involved with this fraud with the
It's okay. 17 has been by the order dated passed in ICCI is erased as 17. Others are service is complete.
Yes.
This is an application filed under Article 227 of the Constitution challenging the order dated 22/6/2016 passed by the learned trial court, whereby passed by the learned court of the civil judge Golaghat in title suit number 9/2015, whereby the application filed by the petitioner herein for vacation of the ex parte order and further for acceptance of the written statement was rejected. From the materials on record, it revealed that the petitioner herein received the summons on 19/9/2015 and thereupon only on 25/1/2016 filed the application for vacating the ex parte order as well as also submitted the joint written statement. However, on account of a delay of 38 days beyond the 90 days, beyond the permissible 90 days, the learned trial court rejected the prayer for acceptance of the written statement. And fixed 27/7/2016 for ex parte hearing. This court have duly taken note of the application so filed, wherein it has been mentioned that it was on account of official problems the petitioner could not file the written statement. It is, however, relevant to take note of that along with the said application filed for ex parte vacating, the petitioner also had submitted the joint written statement. No doubt, it is well settled principle of law that the provisions of order, the Supreme Court in the it is well settled that the provisions of Order 8, Rule 1 is a directory provision. Even if it is directory, the requirement to follow the mandate of filing the written statement within the period prescribed therein ought to have been, is required to be adhered to. However, in exceptional circumstances, the period can be enlarged. In the instant case, this court had clearly taken note of that the written statement was submitted on 25/1/2016 and the delay was only 38 days. This court have also perused the plaintiff is here. Plaintiff is here. Peruse the copy of the plaint. And from there, it reveals that there are serious allegations. As the written statement has already been filed, it is the opinion of the court that said written statement is required to be admitted, taken on record. Accordingly, this court interferes with the order dated 22/6/2016 and directs the learned trial court, that is the court of the civil judge, Gulahat, to accept the written statement filed by the petitioners, who are the defendant number
1 and 2.
1 and 2 in title suit number 9/2015. This court is also mindful. This court is also aware of the fact that on account of the delay which has been caused, on account of the delay and filing a delay in filing the written statement, the suit which was filed in 2015 is still at the stage of pleadings. You want the ex parte? Then don't make the submission. Under such circumstances, it is the opinion of this court that certain cost has to be imposed. In the opinion of this court, a cost of rupees 25,000 would suffice, would be deemed to be reasonable. Accordingly, this court directs the petitioners herein, who are the respondent, defendant numbers 1 and 2 in the suit, to deposit the cost of rupees 25,000 on the next date so fixed by this court in title suit number 9/2015. Taking into account the parties are duly represented, this court fixes the matter before the learned trial court on 13th of May 2024, on which date the petitioners herein, who are the defendants, number 1 and 2 in the suit, shall file the written, shall deposit the amount of rupees 25,000, which shall be a condition precedent for acceptance of the written statement. It is made clear failure to deposit the said amount would revive the order dated 22/6/2016. Footstop. The interim orders which have been passed on 27/11/2016 stand vacant.
Cost in the name of the.
What?
The cost in the name of.
Cost of 25,000 deposit. The plaintiffs in the said proceedings would be at liberty to file an application before the trial court. And the trial court shall, for release of the said amount, and the trial court shall pass appropriate orders.
My objection may be that
What objection?
whether this come under the purview of exceptional and rare cases or not. It's not
Huh?
good. Whether this petition comes under the purview of the exceptional and rare cases or not. That objection.
The
may be
line
recorded.
Mr. So-and-so, appearing on behalf of the respondent, strongly object to the instant proceedings on the ground that there is no, the circumstances stated in the proceedings does not qualify to come within the ambit of exception.
Apply.
Hey, who knows? Equal to top. Hmm. You've taken the survey?
No, not actually.
Why?
Because of the
Huh?
because of the minor,
Because of the
minor the because of
who could not come?
the it is the this day Guwahati minor. She is the mother of the child. It is a guardian kid.
Then
Minor because of that. You would like to stop to Guwahati to stop the
this is a matter pertaining to the what?
minor regard to guardianship minor. The grandmother has filed a case for guardianship of the grandchildren minor. I have filed this responsibility on the grounds of jurisdiction.
Where is the child?
Child with mother at Lokipur. They were born at Lokipur, they are staying at Lokipur. The son expired. The son of the respondent expired.
Now the grandmother is filing.
This case for guardianship of the both the grandchildren at Guwahati.
But the service is not.
My lord, yes, my lord. So, my lord, I have cited the regard with regard to custody. The mother who personally comes with regard to the
But this time I last made it very clear. In the meantime, the petitioner is further directed to take service by way of the state.
my lord, on last service was not complete, and my lord has also requested to service to exit love, but mother is very clear that
Hmm?
my lord, on last day, the matter came up, stated, I had stated that it can be served to exit love also, but the mother has made it very clear that she would like to serve it of her own.
Very well. Then why shouldn't this
So,
service?
my lord, because of the ransom fund, she couldn't come and they put the child children are also minor. One is 5 years, one is 7 years. What they put child.
So why is she taking the trouble then?
My lord,
It is not done to the advocate clerk. It is in Guwahati, you couldn't serve it.
my
I'm not going to stay.
my lord, they
Vacating the stay.
no, my lord, they kindly. So,
No, sorry.
my lord, so, sorry.
So this court, by an order dated 22/3/2024, had directed the petitioner to take effects the service upon the sole respondent. However, no steps have been taken. Taking into account the above, list the matter again on 3rd of May 2024.
And they kindly continue, my lord, may kindly continue to stay, my lord.
What?
My lord, may kindly continue to stay on the.
The more you say, I will reject it. I have not said anything. You tell to the court, the judge forgot it. Yes. But I am not going to stay.
Yes.
Next time cost. Yes, what is this?
So dated eight four the respondent number the answer notice that posted note the address cannot be stated. Regarding respondent number 1, 2, and 4, neither the or answer
Then service.
regarding Dusty, we have taken steps to consult officer Gwalpara. We have not give the report.
You have taken
We have taken
steps.
steps to
Dusty also.
so the clinic time is granted file the ethics.
15.3 we have taken steps. Until now it has not been done. From the office note, it reveals that the service is not complete. The learned counsel, Mr. So-and-so, appearing on behalf of the petitioner, submits that the service has been effected all through Dusty also. However, till date, no information has been given by the petitioner, by the office of the petitioner. List the matter.
In the meantime,
Again.
stay may be continued. Let's stay in.
What?
Let's stay in. Stay may
List the matter again on 13th of May 2024. Interim order passed earlier shall continue till then. It is made clear that the petitioner is directed to take fresh steps again by way of Dusty, routed through the registry of this court, and file an affidavit of service on the next day. Fresh step, because I fixed another date. It is made further to that, if the petitioner fails to take steps in this on the next occasion, this court would be constrained to vacate the interim order. Yes, what is this?
Lordship, name shown for the respondent of F. Verma and
No steps by Dusty.
trustee lordship we have prepared and I have asked to telephone Mr. S. Verma whether you will accept notice on behalf of client. He said he refused to accept.
But have you effected service by way of Dusty or not?
Prepared lordship.
You have not.
Hand
Then
it over to my advocate clerk if the party.
আগৰটো নিচিনা order লিখি দিব. They extended till the next date. আকৌ fresh steps by way of Dusty. Registered to register সেইটো কৰি দিব 13.5 আৰু যদি নলয় will be vacated.
Dusty already
Again, you have to take, you have not effected the steps. So you have to, every time when a Dusty is taken, the date has to be mentioned. Here the date was mentioned till today.
Sorry.
So the next date would be, you are appearing
Lord, it is 22 then I
22. Yes. Very good. 22 he appears.
they have filed divorce petition for I'm not jurisdiction for but they have filed a divorce petition under Christian Marriage Act and Hindu Marriage Act. As per Hindu Marriage Act, section 19 lordship, it is to be filed at Silchar lordship. Marriage lordship solemnized at Silchar. She is also from Silchar.
You are resident of where?
Guwahati, my lord. Guwahati.
And she is a resident of Silchar.
Yeah, permanently Silchar, but they were together at some other places.
Where?
Pune.
Pune.
Where?
Pune, my lord.
So
They were working together at Pune.
go to Pune and file it. That is one of the cause of action.
My lord, my request is the day before yesterday, we have filed the Wakalatnama.
So what? Hardly matters. The question doesn't arise.
We'll file. I will get instruction and we'll file some objections, my lord.
What? What is there to file? You want the divorce or not?
Yes, ma'am.
Go to Silchar and fight it out.
But even then, my lord, he has something to say. If he has something to say, I have to take instruction, my lord. Without instruction,
Do you expect that this court is asking you for a consent? No. This court is directing you to go to Silchar.
there's something to say, my lord.
What is there to say? The last place, there are three places where the jurisdiction lies. One, where a marriage took place. Marriage is in Silchar. Two, where the last resided. That is in Pune. You have to go to Pune. Number three, where the defendant resides. She resides in Silchar. Matter over. You have not gone to Pune. Other two is in Silchar. Go to Silchar.
One with my lord, if it is a,
For what?
I'll take instruction, my lord.
For what? You don't need to. I'm not asking for your consent. Transfer. Transfer. And we'll fix it on 20th of May, on which date she will file her written statement and filter.
Yep.
You can't have it out here because you want to stay out here, you will trouble her. Out there, she will have to come every time here. Not for
Okay.
Master Black.
this take to ground data. This court have duly taken note of. Difficulty. This court have also duly taken note of that in terms of section 19 of the Hindu Marriage Act, 1955,
As with the section 31 of special marriage.
as well as section 31 of the Special Marriage Act, 1954. The jurisdiction to file a divorce proceeding, the jurisdiction to file a proceedings under the under the respective acts are either where the defendant is residing or where the marriage took place or where the parties jointly reside. In the instant case, the defendant, that is the petitioner herein, resides at Silchar, the marriage took place at Silchar, and the parties earlier resided jointly at Pune in the state of Maharashtra. Taking into account that as the defendant presently resides at the petitioner presently resides at Silchar, it is the opinion of this court that the instant proceeding is required to be started accordingly to the case. Which tarikh you will file the written statement without. What is wrong with this court? None has appeared on behalf of the parties on call. The petitioner have not been represented on 3 earlier occasions. It was also brought to the attention of this court that the respondent, who is the husband, who had filed the divorce application before the court of the learned district judge, Morigao, had filed an application for withdrawal of the said divorce application. And this very aspect of the matter was brought to the attention of this court by an order dated 11/3/2024. Taking into account that the petitioner thereupon have never appeared before this court, have not appeared before this court. It seems that the petitioner is no longer interested in the present proceedings, for which the instant petition stands dismissed for non-prosecution. Interim orders so pass stands vacant, and the court of the learned district judge shall Moriga shall hear case to number, shall proceed with the application, proceed with the said suit, being title suit number being so and so, and as well as the application so filed for withdrawal of the state proceeding in a court. The registry shall bring to the attention of the trial court in the court of the district judge Morika about the incident. 40. Yes, madam.
I we have taken steps linking to itself for justice service on
No step.
18th itself, we have taken steps for
The stay.
the stay on 21/3.
You have surveyed. Have you filed the
We have
affidavit of
sent,
survey?
No, Lordship, we have sent to that lady with minor girl, 10 months. Then she returned that she's not in a position to go to IGL and Sabda and is due to her economic condition because the pro bono case. Yesterday we got a notice of return copy. The district has already served a notice by registered post.
Hmm?
Registry has already sent a notice to register post.
The surveys have not been complete. It has also been brought to the attention of this court that although steps were being taken by way of the state, but the state justice service could not be effected on account of the fact that the petitioner could not go to ISOL. Under such circumstances, this court again fixes the matter on 3rd of June 2024. The petitioner is again directed to take fresh steps upon the respondent by way of registered post with usual. In addition to that, the petitioner is again directed to take steps by way of the state to the registry of this court and file an affidavit of service. Interim order passed earlier shall continue till then. It is made clear if the justice service is not taken on the next occasion, this court could be constrained to vacate the interim order.
Lordship, due to threat perception, it is one of my grounds.
What threat perception? There's no, you don't need to go ask somebody else to go. Who has asked
No
somebody
money,
to go?
Lordship, to send somebody. She asked some advocate. They told me, no, cannot serve the notice to that person. And one of relatives, he refused to go because of threat. Earlier,
What
they
is the
threat-
threat in Aizol?
that person is threatened that lady as well as his
Forget about
mother,
the lady. What was the other person?
other person.
Don't make this.
It, by
We'll do
register
one thing.
post, it-
We can do one thing. We'll vacate the stay.
Lordship,
No, you vacate the stay. You go to Aizol and then submit it.
Lordship is so hard,
That is the best way.
so hard.
No, there is no
And,
harshness. There is no harshness. That is why I've given you time. Otherwise, I give time to
It is a pro
30.
bono case, Lordship. That is why I am doing that.
can't help it. The service has to be effective. How can
So
this
it
court
is-
keep on stay?
Through district judge, Lordship.
That is the usual. Usual service is known as through the district judge. One is by registered. Registered is sent by the Indian Post. The other is
Yes.
usual means you take up Alabama step by which it is sent to that
that's the-
concerned court. And
that's-
from the district judge, it is being sold.
Yes,
The
Lordship,
processor.
that procedure.
That is the usual process.
Yes, Lordship,
When we
it is-
say the usual
But
is that,
justice is very difficult to serve somebody. That is my submission before you.
then we'll do one thing. We will cut it. The steps being not complete leaves the matter of the thick.
Interim order.
I'm not saying in
Lordship, kindly give the interim order.
No.
Rather, I will send somebody from my personal side. It is
I
very
ask you
hard
therefore to
decision
do it.
on the part of the court, Lordship. Because she is a very poor lady with 10 months girl that is suffering from.
who has asked her to go?
There's no money, Lordship. There's no money also.
No, then do you mean to mean that this matter should be kept pending? A transfer
No.
matter should be kept pending for all this while?
I'm
Then-
sure. We have taken steps.
Okay,
It is not
Pakistan
that
Nagwa.
Lordship. we
Leave the
have-
matter before any other court.
Lordship, interim order.
I can't pass. I'm not
Lordship,
taking up the matter.
very sorry, Lordship.
Sorry.
Very
I'm not-
well. Don't be so hard, Lordship.
I'm a very hard.
No, Lordship, kindly take it.
Kindly give them interim order may be continued, Lord.
I can't. I'm not taking up the matter.
Lordship, very difficult.
Very difficult.
Very difficult
The
because
next matter is you. Which one? I have given you the three of two.
three,
3-6.
three moods of
Second, after 4 weeks, 6 weeks. Third, not before me. Three of which one?
first one kindly give, I will go. Lordship.
3-6 to no 15 6. 19.
Interim order may be continued.
Earlier I passed. interim. First order.
Alright. Lordship will look into the position of some lady also.
Can't help it.
That's why I'm telling.
You, when you moved the application, you never said that thing.
Which one?
About that you are not going to affect the justice service. Did you say that on the last occasion when you want to go the stay? You never say that.
I never
Because
said.
then
I never said because I did not hear that for the state. Just a position.
didn't hear it then.
I have immediately taken.
I
it up
don't
on
grant a
18th.
stay, madam. I don't grant a stay without a dusty. If the moment I say dusty means that there it would be a stay.
I know. I'm not sure of that.
Yes,
Right.
what is this? Yes, what is this matter?
My lord, we have challenged order dated 11/1/2024.
Hmm.
Which appears at page number 2121.
2-1.
Here, my lord, the learned trial court had given a directive on the submissions made by the
12-1. 11/1/2024.
Yes.
Page 212.
21.
Are represented along with the petitioner, so and so he appeared with the purpose of increasing the Yes, what is this type of order?
Yes, my lord. The members of the governing body of DPS were not the defendant. The principal is the defendant. Yet the court has asked for a personal appearance of all the governance bodies.
Why?
That's the reason why we have challenged this order. And just to give a picture, my lord, why we have approached this honorable court again, my lord, if your lordship would kindly peruse the initial order.
What is the suit for?
Suit, my lord? They have challenged the
Urban Industries for a year.
few days
Or-
back. Your lordship had disposed the matter, same case, my lord.
Which one?
My lord, I was the petitioner, my lord, I withdrew the matter, my lord, because the tender was challenged, my lord.
Oh, yes.
Yes.
Then?
That
was the
order,
matter.
my lord.
Oh, that 8 buses or something.
Yes, yes,
My lord,
yes.
that one.
Yes, then?
That one.
Then that matter,
So
my lord,
this
is what I.
Now, subject, if your lordship would kindly peruse order dated 6/2/2024 of the Honorable Guwahati High Court of this case,
Of this case?
my lord. The lordship will get the clear picture.
Yes. What does it say? Case of the petitioner is that this court. Who wanted to be implemented? Oh, that person.
That is allowed. my
That has been allowed.
And that was challenged. Your lordship has said there's nothing doing, my lord, so they withdrew it. That your lordship thought of.
That I remember.
Yes.
Now that person is the person who has got, because here in this suit, he has challenged the tender condition, the
Right.
tender.
Right.
So therefore, when that order was passed, this court said that nothing.
Correct.
That was withdrawn. Now the implement is gone. Now what is the basis of passing this type of orders by the trial?
That is the thing, my lord.
Yes, Mr. Sahiwala. You were the bar council secretary and chairman. Tell me, what type of these orders are passed?
I can't support it.
Huh?
I
These
can't
orders
support it.
shouldn't be passed. It's a money suit. You have to do it. What is this? They have exercising similar REIT jurisdiction. Even in a REIT, courts are more constrained to do. Not in this manner.
I
They
can-
call
I
what is the suit for? Why?
Suit, my lord.
Huh?
Commercial suit.
It's a commercial suit. You have filed a written statement. The others have filed. Everything has been filed. You are the defendant.
Yes.
I'm the
You are paying for the DPS.
Well, last time your lordship directed my lord that the commercial suit should dispose of as part of.
So I'll
This
set
order
aside
is
this order.
required to be-
This type of orders are not called for. The instant application.
My document has been filed by my, you're right?
It's okay.
Your lordship may record.
Yes, yes. Your name
Given my lord. His name is.
heard Mr. J. Mukit, the learned counsel, appearing on behalf of the petitioner, Mr. J. N. Sahiwala, the learned counsel, appearing on behalf of the respondents.
My lord, the respondent. Yes, that's
The
right.
assisted Mr. J. N. Sahiwala, the learned senior counsel, assisted by so and so, appearing on behalf of the. This is an application under Article 227 of the Constitution challenging the order dated 11/1/2024 passed in commercial suit number 02/2023 by the Court of the Civil Judge number 1, Kamrup Metro at Guwahati.
No, Dibrugarh.
Dibrugarh. Civil Judge?
Civil judge, Dibrugarh.
Dibrugarh. Kamrup Metro at Guwahati.
Kamrup Metro.
Oh no, at Dibrugarh. Civil Judge Dibrugarh. Whereby the said court had directed, not only directed the principal along with, have not only directed the principal of the Delhi Public School, which is the defendant, who are the defendants in the said suit, but also all members of the governing body of the Delhi Public School to be personally present in the court. So, it is seen that the said application arises, the said order was passed in connection with an application filed by one Surya Kant Singh to implead himself as the respondent in the said suit. It has been brought to the notice of this court during the course of the proceeding that the learned trial court, by an order dated
12/2/2024.
12/2/2024, have permitted the said Surya Kant Singh to appear personally, to be impleaded as the respondent number, as the defendant number 3 in the said suit. This court further finds it very pertinent to observe that from a perusal of the impugn order dated 11/1/2024, there is nothing mentioned as to why the court, the learned trial court, was of the opinion that there was a requirement of calling for the personal appearance of the principal as well as the member of the governing body of the respondent number 1. Full.
The governing body of the appellant, number one. Because here, my lord.
Of the defend number 1.
Yes,
Of the defendant.
Defendant.
This court also have taken note of the copy of the plain, wherein the reliefs which have been sought for relates to the entitlement of the petitioner, of the plaintiffs, for continuing to provide the services of 8 number of bus to the defendant till the expiry of the contractual period and other consequential reliefs. This court also have taken note of that the defendant number 1 and 2 had also filed their written statement. Under such circumstances, there was no occasion for the learned trial court to call for the personal direct the personal appearance of the principal as well as the governing body members of the defendant number 1. Accordingly, this court interferes with the order dated 11/1/2024 passed by this court by the court of the civil judge at Dibrugarh in commercial suit number 02/2023. Is there any stay? No.
Stay was there, not of the proceeding by that, but only that
Stay.
part.
Taking into account the above, the instant petition stands this.
Next date is on 29/4.
Huh?
29/4.
What?
The trial.
It's okay.
25.
The service from the office note dated 8/4/2024, it reveals that the service is not complete. Further to that, the affidavit pertaining to the service have also been not received by the section. Consequently, this court fixes the matter again on 12/6/2024. The respondent, the petitioner, is further directed to effect justice service, press justice service upon the say respondent, opposite parties herein, and file an affidavit of service on or before the next day. The interim order passed earlier on 18/3/2024 shall continue till the next day.
Supplementary item 29.
Yes.
My lord, we have challenged both the orders of the learned trial court as well as first appellate court. Our substantial question is, is this, that Lordship may kindly see page 11, man. On the background of the case is like this, one Amir Mia was the original forefather of the appellant and respondent. Now the respondents have original respondents have died.
Who was the plaintiff?
And plaintiff was the respondent. Here respondents.
So they have got a decree in their favor in the trial court,
Yes.
as well as also in the first appellate
Yes.
court, the appeal was dismissed.
Yes.
So you are before.
Yes.
Now, what was the suit for?
Substantial question of law is this. Lordship may kindly see page 11(1). Here, Aminuddin, Imanuddin, and Abdul Mumin, they are the principal defendant. They purchase a plot of land through registered sale deed that has been also made the subject matter of the partition. That is exhibited and without any objection. So that purchase land of these three persons who are the original defendant, that has been made party, part of the partition of the suit land. So that cannot be done.
Which
Second thing is
no,
this,
land
as per Muslim law,
that sale deed is of which land?
within this land.
How do you say so?
Yes, that is Lordship may kindly see. It is their case.
What is the tag number of the sale deed?
Tag number only given. Tag number is only given, but pata number is not given.
No, what was the sale deed?
Kindly see page 33, man. Page 33. As type copy may be sent page 23. Yes, schedule of the land. Bottom, Orgona, Sabghat, Mauza, Chapra, Kotorpur town, block number 3, survey number so, survey of tag number so, under Khotian number 448, 449. So this exact plot of land is not written. Some tag number and Khotian number is given and some
Exact
description.
plot is written within the boundary.
Yes, within this boundary, the measurement of the land is not there.
Measurement may not be there. So what?
But so we are not on that. We are only on that, my lord. Our purchased land, which has been also admitted by the learned trial court, that maybe their judgment, learned trial court judgment may be seen, page 82, madam. Page 82.
Where have you mentioned about your partition, about your purchase land in your defendant, in your written statement?
Kindly say 82 first.
Before that, let us see the written statement.
Written statement, yes, page 34.
Where have you mentioned about the purchase of any land within the boundaries of the schedule?
Yes. Maybe seen page 41. 41. Some description has been given regarding that land. Page 41D. The principal defendants were possessing the strip land of this written statement in as well a dispute arose in between the principal defendant number 1 in one part and principal defendant.
There is no mention in your written statement about the deed of sale.
Deed of sale, my lord.
Then?
That is exhibited.
How can you exhibit something if you have not made anything that you have purchased that land? So that is not your substantial question of law. Next.
Then, my lord, one thing is this, my lord, they claim from Amiral. They claim that their land should be, they claim the land to one Amiral. Amirali had no land. Abbasuddin had land. Abbasuddin is the father of the defendant, principal defendant. they have claimed that Amir Ali is the father of Abbasuddin and also the father of Heba Bibi, Salima Khatun. So they claim that original land was land of Amir Ali. So in that view, as we are brothers and sisters, so we have share. But Amir Ali had no land. They could not prove that Amir Ali had land.
Amir Ali is not there. Abdul Mia is there.
Abdul Mia.
Then what is this, Amir Ali? Mr. Mahmood, you read the file properly. Otherwise, you know, I am very happy to exercise Order 41, Rule 11 in dismissing appeal.
No, is this
At the request of
Now
Mr.
we are-
M.U. Mahmood, the learned counsel, where matters stand adjourned to be listed. How long do you require?
perfect?
Okay. How long after the vacation?
It is a perfect.
Okay. To be listed after in the second week of May.
Almost all the names alias is there. That is the problem. And 32 persons are defendant and 19 persons are plaintiff. So this is the situation here.
Don't worry. It is otherwise a very simple matter.
All.
Item number 4.
So if this I is for restoration, this I is for restoration.
What is this I?
1537 Lordship.
Restoration. When did you file?
Lordship,
2019 itself.
while I took step Lordship, the response number 4 expired. So substitute the legal here.
So what is the ground you did not? It was filed within limitation.
Lordship,
This was filed within limitation.
there is a 4 days delay in filing the second application.
There is the application for here also.
Lordship, IS 781 Lordship, the
Huh.
condemnation petition,
Huh.
there is a 4 days delay in filing the application.
What has happened to the 781 application? So,
Lordship, that is for
then what happened?
thereafter, Lordship, I filed this IA Lordship.
No, this is the main application. IS 781 was before dismissal. It was dismissed on 13/2. 781 is a earlier application.
Lordship,
We are not concerned with it.
Lordship, the
Yes,
1537
tell me.
1537 Lordship.
Okay, now tell me why the delay? Applicants are very poverty-stricken person and the 4 days delay in preparing the security would be concerned. No. Not a fear of occasion as the contractor said. Who is Mr. Asuda
Lordship, my senior
and who is Mr. N. Hawk
Lordship,
also could not appear to the personal difficulty. What is the personal difficulty you had in 2019?
Lordship, my brothers was suffering from sickness.
3 occasions.
I was at home for a long time.
Anything out there? Sure. What was the decree for?
Lordship, the suit was for the right title interest
I mean, RHO.
confirmation of position.
Hey, I mean, who is Mr. Tajuddin Loskar?
Lordship,
Who?
he is also This
Why he was not appearing?
Lordship, only his name is not reflected in the cause list.
So the person who certifies the appeal, his name is not there.
In the cause list, it was not.
You are the plaintiff,
No,
you are the defendant.
Lordship. Title suit was filed.
Sahabuddin expired. When?
Lordship, I came to know, Lordship.
Oh.
In terms of the Lozima court order. P1220.
He was the actual plaintiff, Sahabuddin. You have to substitute. Otherwise, the decree will be final. There's a decree passed
Sir.
of right title interest.
Sir.
Then this was on 14/11/2022. This has happened. Then you have not filed this application. It was recorded in the order. How do I help you? The decree has been final against one. So I can't pass a conflicting decree. If I decide the appeal, even in your favor, I can't because that order is already final. He was a main plaintiff. One of the main plaintiffs.
I may be given some time for substitute.
Absolutely no. This court has no other option. You have not done that. All mistakes of the lawyers. I can't help it. These are all mistakes of yours. You knew it on 14/11. What to do? দেখো এনেইতো এখন ডিসমিসে হয়ে আছে the records reveal that the counsel for the appellant or applicants knew on 14/11/2022 on account of an order new on 14/11/2022 that the respondent number 4 had expired as the same was duly mentioned in the Lozima Court's order dated 3/12/2020. This court have duly taken note of that the respondent number 4 was the plaintiff number 4 in the suit. And the suit have been decreed in favor of the plaintiffs. Thereby, it was a joint and inseverable decree. Consequently, as no steps was taken since 14/11/2022 or even prior thereto, even after 14/11/2022, the instant application accordingly abates insofar as the respondent number 4. Consequently, as the decree against which the instant appeal has been filed, being a joint and severable decree, the instant application cannot proceed. Now, the instant application have also become infructuous in view of the application having abated against the respondent number 4. Consequently, the instant application stands dismissed. Okay, we'll go ahead. Can't help. Liberty, however, is given to the petitioner, to the appellant, to take appropriate steps if so attached. You can do something very different. Because I can't proceed. I hope you understand. Because you are the main counsel from 2019. We have 24, 5 years. You must be understanding. Who is respond number 2, 12?
For 1 to 7.
12, 12.
12.
The record reveals that the service upon the respondent number 11 to 13 have been duly effected. As regards the respondent number 12, the service could not be effected in view of the fact that the service given, the address provided is insufficient. In respect to the respondent number 17, the said addressee have refused the service. Under such circumstances, this court deems that the service as regards the respondent number 17 is duly complete. The appellant herein is directed to take fresh steps upon the respondent number 12 in proper address within 7 days from today. List the appeal thereupon after completion of steps. How many respondents are here?
My lord, there are 5 respondents, my lord.
Okay, you are appearing.
My lord,
LCR received.
my lord, the respondent number 1 and respondent number 4 has died, my lord. Respondent number 1 died on 17/8/2022 and 4 had died on 21/9/13, my
Mr.
S. Hazarika.
S. Hazarika. Did you appear earlier also?
No, my lord.
Did you file wakalatnama for respondent number 1 and that person who died?
No, my lord, it is first time, my lord, wrongly. It was Wakalatnama, it was seen 1 to 5, my lord. Actually, it is signed by 5, 3, and 2, my lord.
Huh?
Wakalatnama is signed by respondent number 5, 3, and 2, my lord.
What is this 5, 3, and 2? 1,
Respondent
2, 3, 2, 3, and 5.
Yes, my lord.
That's why we are going the other way. 5, 3, and 2. Okay, 2, 3, and 5.
Yes, my lord.
Mr. S. Hazarika, appearing on behalf of the respondent number 2, 3, and 5, submits. Who are they to the respondent number 1 and 4?
Bhagwati Devi 1.
Who are they to the respondent number 1 to your clients?
1
Who
is, my
died?
lord, the daughter, mother of, my lord, the respondent
Hey,
number 3.
Mukhalti.
First when the papers returned back, my lord, then again,
Don't confuse Mr. Counsel. The
the-
simple aspect, don't make it.
the difficulty is that papers taken away, my lord, then again they have sent.
One,
One is the
and
mother.
who died?
Bhagwati Devi, respondent number 1, my lord. Bhagwati
One
Devi.
died, and
One died.
four died.
4 died, my lord.
4. When did 4 die?
On 21/9/13, my lord.
21/9/13. 13.
1/3, my lord. 13. 1/3.
4 died on 21.
9/13.
How is it possible?
Yes, I have received
1/3.
1/3, my lord.
So in the second appeal, when it was filed against the dead person, what is this you are saying?
My lord, this is a typing mistake, probably 23, my lord. 29, 21, 9, 20, 23, my lord. That's why. Sorry. They have sent
Mr.
typing mistake.
Counsel, don't make all these submissions. Eh?
It was sent by the lower court counsel as 13 April.
No, we can't trust you, na? Very difficult to trust. And the many. Who is Siddhant Kamini and Anita Kamini?
Siddhant committee is the daughter and son, my
Huh?
both are daughter and son of Surendra Khemani. They've already signed the work.
Hmm. Chal. You have the proper date.
My lord, it was 10 as 13, my lord. My lord, kindly allow me to correct give the proper date.
Find out.
About the Khemani, my lord. About the Surendra Khemani, response number 4, my lord. And I have the proper date of response number 1.
We will take it up at 2.
My lord.
Get the information when he did right
That,
and inform this.
yes, my lord.
Then he will file appropriate application.
Okay, ma'am.
And don't come up with a confused state of mind. What you
My lord,
2013 he has died.
obliged.
We'll take it up at 2,
My lord.
Mr. Mishra.
Please, my lord.
Hmm.
As per the office note, the service has been completed upon all the respondents.
Service being complete. Service has been completed. However, it is seen that the LCR of attitude number 305 705 of the 2006 have not been received. The registry is directed to forfeit the requisition. The LCR of TX number 705 of 2006 and upon receipt of the same list the matter for hearing
Obliged.
in its usual course.
My lord, I am for applying for respondent, my lord. 2 weeks time may be allowed to file objection, my lord.
Cost?
Yes, my lord.
Because last time also so you sought for time.
No, my lord, my junior case short time, my lord.
So how does it make a difference? You and the junior every time, and tomorrow another counsel
Yeah,
will come
because I
and
understand.
my side,
The
this person has
copy
done.
was not received. That day
So
copy
Mr.
was.
Tamuli, Miss Tamuli has
Nah.
submitted that she appears today in the
Extra copy.
matter for the file and therefore takes some time to file objection. In the meantime, extra copies of the petition
ma'am.
be furnished to
Well,
Mr.
earlier there
Lever.
was some other counsel, my lord. Earlier there was some other counsel.
Yeah.
One lady was.
How many times you will
No,
get the copy?
one chance, my lord. After you
What is this order for?
for condemnation.
Delay for 18 days.
Huh? 18 days?
Yes, my lord.
Don't make all these things.
My lord, I have not.
Therefore, this is an application,
Delay is not properly explained also.
not necessary. 18 days we don't mind. We will consider something better. This is an application for condone under Section 5 of the Limitation Act 1963 for condoning the delay of 18 days in preparing the accompanying second appeal against the judgment and decree dated 11/8/2022 in title appeal number 02 of the 2022. This court have duly taken note of paragraph number 3 and 4 of the said application and is of the opinion that the same constitutes sufficient cause for condoning the delay of 18 days. Accordingly, the said delay of 18 days is condoned. The registry, the IA stands exposed. The registry is directed to register the accompanying second appeal and list the matter at the stage of Order 41, Rule 11.
Problem.
Right. Itu here, ako na ulit. On parats. Yeah. I just put it up on it. It is directed to both for the title. For which in this period. It is only title to number 2 for title 52 of 2000. 52 of 2050. Service is complete. However, LPR of 32 of 50. You are the only one.
So respond. LCR
LCR has to be called for that.
title suit number 52. Problem.
What about steps upon response number 1 and 2? Wrong address,
Step was taken.
not known. That is the service. You go and serve it. They couldn't find out. So you go and file.
Due to incorrect PIN number.
Tell.
Please. Give me a chance to test.
The learned counsel appearing on behalf of the appellant submits that you may be permitted to take fresh steps by way of registered as well as usual upon the respondent number 1 and 2 by in the proper address. So 7 days time is granted for that. What?
7
Time is granted till 2. We can vacate the stay. Is there in time order?
No.
Then I can first decide the RSA. Without them, why should we trouble you with steps? 7 days. The taken steps be taken by 10th of by 19th of. Yes, what is this?
What is this? I have for contestation of figure 77.
You are appearing?
Yes, I am appearing for respondent number 1. Okay, one thing which transfer from the face of the record, Lordship. You wanna kindly see the index. Index of the application. There is no date when this application is filed. Then next page also, your Lordship, filing date also there is no date.
No, filing is on 18th of March.
Yes, 18th of March. Now your Lordship kindly come to paragraph 3.
Yes.
That the appeal has been filed before this honorable court today. That is 13 to 23. They are saying 13 to 23. Then again, it is in paragraph 7 also. Paragraph 7 also, Lordship. Then kindly see the affidavit, Lordship.
They filed the appeal on 13 to 2020.
Yes. Lordship kindly see the affidavit. Affidavit is on 14.
What is?
That cannot be on 13, Lordship. This affidavit.
Huh? Affidavit on?
This affidavit, Lordship, filed on sworn on 14.
Oh. This affidavit is for condonation. Condonation application can be filed subsequently. Limited. What is the ground?
Down it says the lower court, appellate court counsel has informed has not informed about the passing of the judgment, which says appellant subsequently came when partner is expected.
Who is the appellant court's judgment? Lawyer?
Lawyer is different, Lordship. Appellate is some each or my.
Huh?
That
Because when you mention, when you make an allegation against the lawyer,
Yes.
the section 5, which requires a very liberal interpretation, in my opinion, requires a very strict interpretation. Okay? So now when you do it, you have to show that what are the things, what has happened, have you mentioned everything or not? Else I'm going to dismiss your application. I don't like the lawyers blaming lawyers.
Not blaming lordship. What happened?
No, no.
A
You
para
have
four
to
lordship.
show. Unnecessarily, I'm not going to do it. Because this practice has to stop.
Appellant counsel was the Sandeep Sharma.
So,
But appellant.
where is the mention?
In the application, there no name has not been
Then,
given.
what are the steps? When did you go and meet him? When was the judgment
on
pronounced?
on 5, that is given as explanation at page 4, lordship. May I read it? That is that the counsel for the applicant conducting the first appeal before the learned first appellate court below has informed the applicant regarding the passing of the judgment only on 5/1/2023 when the applicant contacted him in the court. Accordingly, the applicant asked her counsel to obtain the certified copy of the same, which was received by the counsel for the applicant only on 12/1. Thereafter, the counsel for the
When was the judgment passed?
judgment on 24/8/2020.
Okay, then.
Then also immediately thereafter, para 5, contacted P. Datta, senior advocate, over phone for filing the second appeal, but he was asked the applicant to come to his chamber on 22/1/2023 along with all relevant documents. In that process, P. Datta was in out of session due to his treatment. Accordingly, on 21/1, the applicant contacted P. Datta in his office chamber, who, after going through the relevant document, asked the applicant to hand over all the documents to the data at Guwahati for preparation of the appeal and necessary application. Para 6, thereafter the applicant contacted data and so
So this, as on 12/1/2023, the judgment was passed on 24/8.
Yes.
When did you apply for the certificate?
certificate copy apply on 5/1,
Applied on 5/1.
12/1.
Huh?
Council applied for 12/1.
So on 12/1 you applied and 12/1 you got it.
No, 5/1 should apply. Page 85.
5/1 you applied.
Yes. And
Then?
12/1 council got the copy, which received the appellant on 17.
Then?
And accordingly, appeal is filed.
File an affidavit of that counsel. The counsel, Pandit. What is sir? Pandit Sharma. That he informed only us after such a late.
The appellant is a lady widow of 76 years.
So what?
Therefore, she doesn't have the
No,
phone.
file all these things. Because you can't keep on blaming. The blaming game has to. The lawyers cannot have. One has to be very strict. Otherwise, I'm very lenient. 5 days is 77 what? Till 500 days, I do not touch. But when you are saying about the lawyer's mistake, then in that case, you have to.
That's not his mistake, but the lady do not have any phone. So therefore, council not contact. And she personally visited the
Lady doesn't have a phone.
phone, but poor lady widow 76 years.
She's poor lady. Why are you saying she's a poor lady?
Poor lady widow husband died.
Huh? What is the suit for?
Suit for declaration and permanent intent.
For?
Declaration that their case is that the defendant.
Who is the plaintiff?
Plaintiff is the respondent number 1.
And what is what they are asking for?
Asking for declaration lordship that the defendant is illegally constructing houses over the
Poor lady. Poor lady constructing houses.
700 square feet of land.
So what? Poor lady constructing houses. Can't happen.
So she come from East Bengal and her father-in-law came from Bangladesh and then
Is
occupied
applied
that
for
land.
car? Applied on the car? That? Don't make all this stuff. You can't blame the advocate.
Only 77 days.
77, that is a subject to cost of that person. Because blaming the lawyer, I am not going to give. File an affidavit of that lawyer, because then I will impose a cost upon him. Otherwise, we will keep the bar license in suspension. This is what I am doing nowadays. Impose the cost, and if they don't pay, then keep the bar license in suspension. So file an affidavit of annihilation. Yes, not yours. Of that advocate, it has to be filed. That why did he report so late? Well, this is not it's a very serious thing. A clear-cut message has to go to all lawyers. So this court is not going to entertain. You lawyers don't feel that a legal profession is a noble profession. At the drop of the hat, you make allegations against your fellow lawyer. This is what is happening. Isn't it? Yes. Every day, you will find 4 cases every day while taking a bench that the lawyer is being. At least you have to have the basic decency to take care of your lawyer fully. Don't make just for the sake of making it. That is one of the ethics of the lawyer. That not to make, don't do whatever the client says. Client may say anything. The lawyer has not done that. Have you inquired? Who has drafted this? Have you inquired? You have not inquired and you have drafted it. Whatever they say.
Because they say that.
And she say, kindly see, you put it that it is true to your knowledge. And true to your knowledge means the knowledge on the date of happening. So the judgment, when you say that the judgment was pronounced on such and such date, and you say it not true to the records, but true to your knowledge, means that you knew about that on that date. See, your affidavit, 1 to 9. I hope she has put this. She has put it 1 to 9, true to your knowledge. So how can you say that a lawyer informed later? Tell me.
I'll ask to obtain a affidavit. Sometimes happens you could not able to contact client. Several of my cases I have submitted letters.
So whose mistake it is? Whose mistake it is? It is not the lawyer's mistake. It's the mistake of the client. And why the client blames the lawyer? And the lawyer out here is happy to make that allegation against that lawyer. He may not be able to contact. She may not have given the number. Is the lawyer supposed to go home and to the counsel out there, to the party out there and go home and look here, tell him that look here, this is this?
Therefore, they visited us.
Who visited?
The appellant visited.
Obviously, it was our duty.
That part is there.
Then, how can you blame the client, the lawyer?
It is her duty to
protect. It is our duty.
But
I would have understood in the High Court if something happens. Because here, matter one day comes and there is no date fixed. But in trial court, first appellate court, every day there is a date fixed.
But the e-court services also available now.
The e-court services are there. Without, when did you file your mobile appeal? The appeal is filed in 2019. When do you file the appeal, your phone number is also being there. 2000. Yeah? You don't know, you don't practice in the trial court?
No. I do not have the knowledge whether appellant's phone number is there or
100% it will be there. Because this is one of the e-court services. And immediately it is given out there.
in most of the cases, counsel's number.
No, most of the cases, the lawyers, they don't give the client's number. Because the client's number, if it is given, it will show that a particular date has gone and the lawyer had only given something, nothing doing, sought for an adjournment. That is the reason why the lawyers, they don't try to give it. Yes, they can condone the delay. 77 days, okay. What to do? You can't put the dog's tail, make the dog's tail straight.
Regarding the explanation given, it's between the her and the lawyer. We have no knowledge about what.
No, it say it to be true to the knowledge.
Acceptability.
It's only because she's 75 years old and it is on below 100 days, this court is doing it. Now, this is an application under Section 5 of the Limitation Act for condoning the delay of 77 days in preparing the accompanying appeal against the judgment and decree dated 24/8/2022, passed by the learned civil judge in Sukia, entitled Appeal number 5/2019. Puस्तक. This court have seen the grounds and reasons stated therein, and also the fact that the applicant is the widow and it was did not and was suffering on account of old age ailment, for which this court is of the opinion that the same constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act. Accordingly, the delay stands condoned. I stands disposed. And with the raised reasons. Before parting with the record, this court expresses deep remorse at the conduct of the counsels in filing applications, blaming the trial court lawyers, trial court as well as the first appellate court lawyers. This particular practice requires to be remedied in as much as the legal profession is a noble profession, and the counsels have a duty to keep the noble the profession noble. Here, not a Yes.
Yes.
Service is complete. Madam, you are appearing for a performance defense response. Now, this is an application under Section 5 of the Limitation Act for condoning the delay of 114 days in preparing the accompanying second appeal against the judgment and decree dated 30/3/2022 passed by the Court of the Learned Civil Judge, Karimganj, in title appeal number 14 of the 2020. The applicant have duly explained the delay in paragraph number 2, 3, and 4 of the said application, stating inter alia that on account of medical illness of the applicant as well as of his wife, he could not take immediate steps. Taking into account the state grounds which have been taken, and there being no objection by the respondent, in spite of service of notice, this court is of the opinion that the delay in the instant application can be condoned. The grounds which have been assigned in the opinion of this court constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act. Accordingly, the delay of 114 days is condoned. I stands disposed of. The registry shall register the accompanying second appeal and list the appeal in the state of Order 41 Rule 11 in the before this court.
And then put the GFM tone in the constitution.
Her name is
The GFM.
Some
Please, your lord.
Type by the state.
yes, what is this?
It's type.
For what? 41 Rule 3A.
Yeah.
My lord,
119 days.
regarding the thing, my lord, regarding the representation of the opposite party is concerned, my lord, there is some mistake, my lord, here. If your lordship would kindly see the office note dated 31/2024.
Hmm.
So this was pursuant to the earlier order, this caveat, because our names are shown on the basis of some caveat. So I had made the submission that I have filed some caveat, let the caveat be tagged along with this. Now it seems that as per this office note, as per information provided by the filing section, caveat number 348/2023 has been tagged with IA number 1364/2023.
There's an IA.
My lord, this IA is of one Bediüz Zaman. That case your lordship has already disposed of on 18/3. So we had filed the caveat for this Bediüz Zaman and not for Sayyida Wahida Rahman. So we don't hold a wakalatnama for Sayyida Wahida Rahman. So some mistake has been committed while filing, my lord, the thing, because I have checked the RSA record, my lord.
So you are not appearing for Saida Wahida?
No, ma'am. No, ma'am.
Okay. We'll make it clear because earlier there is some order being passed out here.
Yes.
That he has filed one caveat which is not tagged with the record. Therefore, registry is directed to tag caveat number with record Mukit so and so further submits that he has received a copy of the memo of appeal, but a copy of the interview is not provided to him and all.
This thing is there, but this caveat, my lord.
But you have no wakalatnama for this.
No, ma'am.
There is only one opposite party here.
My,
You are not appearing
no,
for Mr. Mr. Z. Mukit, the learned counsel appearing, the learned counsel submits that inadvertently on the earlier occasion, it was informed to this court that he was representing the opposite party, inasmuch as he had no power. He had not yet been given any power to represent the opposite party. So, under such circumstances, this court issues notice upon the opposite party. The applicant is directed to take steps upon the opposite party by registered court along with usual. List the matter on 19th of June 2020.
Your lordship, please, our names may be.
The registry shall spec off the name of Mr. Jed Mukit and other counsel's name.
Right, obliged.
Huh? The counsel appearing on behalf of the applicant submits that he may be permitted to take fresh steps.
And we have also that he may have changed the address.
On the
The
counsel appearing on behalf of the applicant submits that he may be permitted to take fresh service steps upon the respondent. In addition to that, the learning counsel submits that he would like to take service upon the respondent by way of the state. Taking into account the above, this court directs the applicant to take fresh steps by way of registered post upon the respondent within 3 days. Within 19/4/2024. Further to that, the applicant is also directed to effect dusty service upon the respondent routed through the registry of this court and file an affidavit of service on or before the next date. List the matter again on 9/6/2024. No, not 9, 10/6.
We have five, one for the sub repair, the second one for setting aside evidence, and the third one is the photo in public. Unfortunately, the date we have not record. So my lordship kindly grant some time.
Huh?
The date is not record.
Who died?
Appellant number 1.
How much delay? When did he die?
9/12/2020.
And when did you file the application?
In the month of June 2023. ma'am.
Huh?
June 23.
No. Application was filed on 28th of October 2023.
But copy served to us, which is as per affidavit, June 23.
Or June 23. Can't be June 22.
23.
23. Why there is a delay? Who was the original appellant? Rajendra Gwala.
Yes, ma'am.
Who is Sunita Gwala? Sunita Gola is the wife. Huh? Isn't it? Who is responsible? The appellant number 2, 3, and 4.
Sunita Gwala, wife of appellant number 1.
Rajendra Gwala died.
Yes. Wife
Sunita
of-
Gwala is the wife.
Yes.
Number 3 is the daughter. Number 4 is the son.
Yes.
Number 5 is the son, daughter. So these are already there as the appellant. If that be so, where is the question of abatement? These applications can be converted into an application under Order 1, Rule 10 and implement them. That's all. Unnecessary. Because the estate is duly represented.
Yes.
Then what is there unnecessary making it delayed? Isn't it, Mr. Chakraborty?
Yes. But
Because it cannot abate, taking into account the legal representatives are already there. So Order 22 Rule 9 or Order 22 Rule 3 does not apply.
Yes.
So these applications can be converted into Order 1 Rule 10 and implement them as also the applicants. That's all.
other applicant.
Other applicants. I think that is because they are also some daughters of
Yes,
something.
daughters, all daughters.
They are also daughters. These are all daughters. Laho, it we can apply. Not necessary to make all these things, okay? Because unnecessarily, why should we delay unnecessarily? Laho, 117, 118. It has been brought to the attention of this court that the appellant number 1 expired on 9/12/2022. The appellant number 2, 3, 4, and 5 are the legal representatives of appellant number 1. And as such, the estate of the appellant number 1 is duly represented. However, by the instant 2 applications, the petitioner, the applicants have again however, the 2 applications so filed pertains to an application under Order 22 Rule 3 of the Code of Civil Procedure 1908 and Order 22 Rule 9 of the said code. The question of abatement and the question of substitution of the legal representative, in the opinion of this court, does not arise, taking into account that the appellant's estate is duly represented by the appellant number 2, 3, 4, and 5. However, it is noticed from these applications, that the appellant number 1 also has 3 other daughters. These applications under Order 22 Rule 3, that is IA number
117.
116, 118.
118 substitution, yes.
118 is Order 22 Rule. This application under Order 22 Rule 3 is converted to an application under Order 1 Rule 10. And accordingly, the 3 daughters, namely Srimati Sarita Gwala, Srimati Momota Gwala, and Sri Sangeeta Gwala, are arrayed as appellant number 1A, 1B, and 1C. Pusto. The registry. No, pusto. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties, amended memo of parties before the registry of this court on or before 19/4/2024. Pusto. The registry shall, on the basis of the said memo of parties along with the incident order, make necessary correction in the records as well as also update the same in the CIS. Pusto. Accordingly, both the applications stands disposed. Pusto. Here, this court have also duly taken note of. This court have duly taken note of that the LCR have been received and the respondents are duly represented. Considering the above, list the matter for hearing in its usual course. You got the memo party. When did he die?
My lord, in respect of response number 1, I have received the death certificate, my lord. In respect of response number 4, I have not get the instruction, my lord. I have called pick up. In respect of response number 4, my lord, I did not get the instruction.
But has he died or not?
Yeah, he has died, my lord. Well, in respect of response number 1, I have received the death certificate. Kindly take up the reopening, my lord. I will place the death certificate of the death number 4.
What is your name?
My lord.
Your name?
S. Hazarika, my lord.
Mr. S. Hazarika, appearing on behalf of the respondent numbers 2, 3, and 5, submits that the respondent number 1 had expired on.
My lord, expired on
that too.
17/8/2018, my lord. 17/8/2018.
17/8/2018. Show me. This is filed against the dead person.
Judgment was passed on 23/12/2019. Appellate judgment was passed on 23/12/2019.
17/8. And appellate judgment was, it's a judgment of reversal.
No, my lord. Concurrent finding.
Confirmation. Had died on 17/8/2018. From the said aspect, from the said aspect, it is clear that the respondent number 1 expired prior to the disposal of the first appeal. Inasmuch as the judgment and decree passed by the learned First Appellate Court is on 23/12/2019. However, it is noticed that the respondent number 1, respondent number 2, 3, and 4 2, 3, 4, and 5 are the sons of the respondent number 1. And as such, the estate of the respondent number 1 was duly represented even in before the First Appellate Court. Mr. S. Hazarika further submits that to his information, the respondent number 4 had also expired Full stop. However, he has no date on which it had expired. He had expired, for which he submits that he would require some time to take appropriate instructions. This is the matter again on 26th of April 2024.
I'll place the death certificate.
Huh?
I'll place the death certificate of the my lord as to number.
Very well.
Obliged.
The death certificate of Mr. of the respondent number one is kept on record and marked with a letter X.
Obliged.
What had happened?
Well, the finance department was asked to obtain the instruction whether ACPS is applicable to AIDC. If ACPS is not applicable to AIDC, then approval of the finance department is not required. Just to prolong the matter, my lord, we have taken up this plea.
Oh, did you submit that document?
Yes, Lordship. We submitted.
Then what happened?
Lordship, one letter was sent to the parent department. Lordship. Was
So, finance has no business.
Just to replace. Because of time that I have been completed time. Just to replace. AIDC has said that memorandum came into effect from 13/9/2013, and I became eligible prior to it. And they have not adopted ACPS, they have adopted a modified SLAC.
So you were entitled as on 1/1/2013.
Yes.
Then?
And AIDC, your lordship will find, it gave MOU was with the government, it came into effect from 13/9/2013. That is the date of adoption, para 11, page 226. And they can't adopt a grade pay without postings. That's why. They have just adopted a grade pay that has no place against any particular post. That they have just taken one grade pay and adopted. Not grade pay is always against a ROP against your lordship will find it's always against a particular post. Basic is that MOU came into effect after we became eligible.
You belong to which department?
Assam Industrial Development Corporation.
Yes, I know. Which department?
Company secretary.
Company secretary.
Company secretary.
Company secretary has a department.
No, Lordship.
Okay, so above the company secretary is the managing director.
Yes.
No, DGM.
Huh? What DGM? There is no DGM.
GM.
GM. There are two posts for GM. One for
Company
administration.
secretary grade 1. Company secretary grade 1. So where is the GM post is there?
No, no. There, from the company secretary, the GM post is not there. GM post is in technical and one personnel.
So we'll get the financial benefit of as per the page 31. Slide.
Page 31 of your requisition.
Yes.
Where?
Scheme A.
Yes.
An employee who completes 10 years continuous satisfactory service in the same grade or post and is otherwise suitable for promotion to the next higher post as required under promotion rules, but remains stagnant due to non-availability of vacancy, either for filling up the post by other incumbent or no further sanctioned post, this is important, will be eligible for being placed in the next higher scale in the approved pay structure as his personal scale of pay. The higher scale that may be granted as per personal scale of pay shall be restricted to the existing higher scale of 11,000, 25 to 17,000. In other words, employee up to the level of deputy general manager in the scale of so-and-so will be entitled to this benefit in case of upgradation of scale from the level of deputy general manager to the scale of so-and-so. So since there is no post.
So you are entitled to 11,025.
Yes.
Huh?
Yes. That's 17,000.
So there being no post.
Yes.
And they have already completed 10 years.
Yes.
And what is this written argument you have submitted, Mr.
Yes.
Gustami?
Before that, Lordship, page 31D.
Huh?
Before that, Lordship, page 31D.
Yes.
The sanctionation benefit will not lead to create of any post in any form. Number one. Number two, in I, the scheme will not be applicable to those employees who are not eligible for a promotion to the next higher post due to lack of requisite qualification. Now, for GM Lordship, she has no requisite qualification.
What is the requisite qualification?
Yes, Lordship, GM one technical Lordship.
No, no. What
Yes.
is the requisite qualification?
Well, this I at page 32 is only applicable
Wait.
4 years experience as Deputy General Manager, Personnel and Administration with PG degree diploma in Personnel Management, Industrial Relation, Social Work with Personnel Management and Business Administration with Personnel Management from recognized institution, degree in law with will be an added advantages.
Added advantage, we are not concerned.
Yes.
What is the qualification? Where is the qualification? for
Eligible
the-
norms for promotion. It is page 51, Lordship, 51 in my affidavit, Lord.
running page?
Running page 100, Lordship. 100.
How many company?
For DM technical, they say that they will require engineering institute BTech degree. But I'm not asking for upgradation of the post to GM. Only I'm asking for the upgradation of my scale of pay because of stack.
Okay, wait, let us see.
Yes.
Yes. General Manager, Personnel and Administration. 4 years experience as a Deputy General Manager, Personnel or Administration with PG diploma. Degree, diploma in Personnel Management, Industrial Relations, Social Work with Personnel Management, Business Administration with Personnel Management from recognized institution. Yeah. Then what? There are two types of GMs.
Yes. One technical.
What
It
is the
not belong-
technical GM?
Technical or engineering
Yes.
institute.
The technical post it is the engineering
Engineering institute BTech degree.
BTech degree from engineering institute.
So are you saying that a person who entitled to BTech degree or this degree would be only entitled to slash, but otherwise no.
Because Lordship, it is I is there, Lord. I is there. It is stated that for scheme will be applicable to those employees who are not eligible for promotion. Is not applicable.
But isn't it the post of deputy company secretary equivalent to deputy general manager PNA?
Yes.
If that be so, why not they would be entitled to?
Yes, company secretary is equivalent to the deputy general manager. Company secretary. Right.
As per the draft which you have given out here in your written argument, there the company secretary is shown higher than the deputy general manager.
No, presently he drawn.
Basically, there is no post of PM company secretary.
Yes.
So there is only a post of PM
Mr. Devkon, kindly Bhaskar Devkon, kindly appreciate one. Why is this matter listed before this court? I hope you remember that I have remembered those.
Yeah.
You don't need to say.
Yes.
I'm not. This beautiful diagram.
Everything is there.
Yes. What is this? You are putting the deputy general manager with similar place with deputy company secretary.
Yeah. Yeah.
And intentionally, you have put the GM above the company secretary in the diagram. It's a little bit above. Where is the judgment on stagnation? Why the Supreme Court says that there should not be any stagnation? Why this MACP plan is required? Where is the judgment on that?
Well, I'll give it. But this is the judgment of this technique. I'm doing it. I don't have a printout.
So Mr. Gustami's only cases on these two. There's nothing else. It's circular. You say D and I. That is your case. Nothing else. So this roadblock needs to be clear. That's all. So for that, Mr. Moore has to help me out.
Yes.
Giving me that judgment.
Yes, sir. I have it saved it back.
Seems Mr. Kaur is not interested with the client.
More than
Otherwise, he would have been ready with that. That is the only point.
yes.
I'm ready to dictate, but
Yes,
I don't have the ear to dictate.
Well, I'll give it MJ Prasad versus Garrison Central Data. Just save here.
What? Supreme Court?
Yes, sir.
Prasad? There is no MJ Prasad.
Yeah.
Your lordship can look into this, judgment of Union of India versus X if you have.
The hook. You find out.
Yes, actually. Yes.
Let me dictate.
Yes.
You find out.
Yes.
I think all things has to come to an end. Too many applications, too many. This is an application under Article 226 of the Constitution. Challenging the office memorandum bearing number AIDC oblique ESPT oblique I bracket T oblique 3300-09 dated 13/9/2013. Semicolon. For setting aside and quashing the office memorandum number AIDC oblique ESPT oblique I bracket T oblique 3310-19 dated 13/9/13. Semicolon. A writ in the nature of mandamus directing the respondent to grant the payment of rupees 26,000-45,000 plus GP, rupees 8,700. That is the payment of the next higher grade, higher post under SLAS with effect from 31/12/2012 and for other consequential benefits. And further, for a direction upon the respondents to create a personal post of General Manager bracket CS to save the petitioner from stagnation in service with all consequential benefits. The last cannot be granted. Isn't it, Mr. Goswami? The last prayer cannot be granted. The different thing a person may be entitled to the next higher grade, but the question of granting a direction or having a post, personal post, does not arise. Unless they don't, that post does not exist. Because it is absolutely within the domain of the executive. For deciding as to whether the petitioner herein was initially appointed in the post of Assistant Company Secretary in the year 1995 in the pay scale of rupees 2,555-4,600 and subsequently was upgraded to the next higher scale of rupees 9,075-14225 as Assistant Company Secretary. In the 18th DPC-PAC meeting held on 31/7/2001, the case of the petitioner was considered for promotion to the next higher grade of Company Secretary in the pay scale of 10,000-050-15,575. The eligibility criterion for promotion to the rank of Company Secretary was a 4 years post qualification experience as Assistant Company Secretary in the scale of pay of rupees 9,075-14,225 and must have passed the ICSI final examination. It is the case of the petitioner that as the petitioner duly qualified as per her qualification. She was duly recommended by the 210th Board of Directors in the 210th meeting of the Board of Directors for promotion to the post of Company Secretary in the scale of pay of rupees 10,000 050-15575. However, before the promotion of the petitioner could be effectuated, the respondent issued the office order dated 21/9/2001 by which certain restructuring was carried out in respect to the executive cadre post of Company Secretariat Department. In view of the board's approval, in view of the approval of the Board of Directors in its 205th meeting held on 1/9/2001. Accordingly, the previous post of the Company Secretariat Department was redesignated. Whereby the post of Assistant Company Secretary was redesignated as Company Secretary Grade 2, whereas the post of Company Secretary was redesignated as Company Secretary Grade 1. In accordance thereof, the petitioner, the respondents had issued an office order dated 21/9/2001 by which the petitioner was redesignated as Company Secretary Grade 2 in the existing scale of pay of rupees 9,075-11025-11025-400-11825-EB-400-14225 with immediate effect. Taking into account that the post of the Company Secretary, Assistant Company Secretary, which the petitioner was holding, was redesignated as Company Secretary in Grade 2. The petitioner was under an expectation that she would be granted the promotion to the post of Company Secretary Grade 1. In terms with the recommendation made in the 18 DPC-PAC dated 31/7/2001. However, nothing happened for which the petitioner submitted a representation on 8/10/2001. Subsequent thereto, on 31/12/2002, the petitioner was promoted to the rank of Company Secretary Grade 1 in the pay scale of rupees 10,050-157,575 plus other allowances as admissible under the rules of the corporation with immediate effect. The said promotional order was subject to satisfactory service on probation period of 1 year, which was subject to extension, failing which she would have to face reversion to the post of Company Secretary Grade 2. In the meantime, it is another very interesting aspect came into light. Inasmuch as the respondent corporation issued a circular on 21/9/2001 implementing the policy decision of inverted comma service linked advancement scheme for employees of AIDC Limited, inverted comma close, for short, /SLAS. Put- This code would deal with the various clauses of the said circular at a subsequent stage of the instant judgment. However, it is relevant to take note of that the said circular was issued with the basic objective is to remove with the basic objective to remove stagnation and to motivate for effective working amongst the employees. At this stage, it is also relevant to take note of that there is no promotional post in the cadre of company secretary in the respondent corporation. From the post of company secretary grade 1. Taking into account that the petitioner had completed 10 years on 31/12/2012. It is the claim of the petitioner that she is entitled to the financial upgradation to the next higher scale of pay in the hierarchy of rupees 11,025-17,000, which is in the rank of the general manager. Under such circumstances, with the completion of the 10 years on 31/12/2012, the petitioner submitted a representation on the same date. Under such circumstances, under such circumstances, the petitioner submitted a representation on 13/12/2012 to the managing director of the respondent corporation, that intimating the later that she will be entitled to the next higher scale of pay, taking into account that she will be completing 10 years of satisfactory service on 31/12/2012. The said representation was kept pending. And in the meantime, the 6th Central Pay Commission, this is the 6th Pay Commission, State Pay Commission, yes, not Central. The 6th State Pay Commission was adopted by the respondent corporation, whereby the scale which the petitioner was seeking on the basis of the representation, that is rupees 11,025-17,000, was replaced in PB4 in the payment of rupees 12,000-40,000 plus gateway of rupees 7,400. Mr. Kumar, you are asking for 11,025 to 17,000.
Yes, yes.
Then what was the revised pay scale? 12,000 to 40,000 or 12,000 to?
I'm just checking. Page 39. Page 39.
Yes.
Order for finance next has going to payment of from our existing payment of so and so. Just check. I'm just checking. This is the which I'm getting at the moment, madam.
It's okay.
I have
Also, tattoo.
good.
On 13/9/2023, the first impugn order was passed. Office order was passed by the managing director of the respondent corporation. Why are you challenging the first one at page 36?
Well, page 37, that
That 37 will go, yes, what does 37 say?
paragraph 5.
Yes, why? Why are you challenging this?
Because well, that we have just picked up that 7,600 without any post from the division of ROP. Because ROP, that scale of pay is always against a particular post. They have just picked up that scale which was not because in the one chart you also will find that AIDC did not have it. That you also will again find in their office order at page 36.
That is why are you challenging this?
7,600.
No, not the, you see, why are you challenging both?
Or 36.
36, why you are challenging? When 38 also deals
only,
with
madam.
you. Specifically deals with
Yes,
you.
but only the last paragraph is specific to me, and this is the.
So
this
why
36
is it required to challenge that one? 36.
Because 37 this 38 is the second impugn order is based on this first impugn order at page 30. Only they have.
Why do you say so?
Same, my lord, your lordship will look into the context.
Why you are saying that the base, it is based on the first one? It is not mentioned.
No, but your lordship will find the
Contents are same.
yes,
But no,
contents-
contents is different because of the fact that the second impugned order
yes,
deals with you,
yes, specific.
whereas the first impugned order does not.
Yeah. Your
So
lordship
that is not relevant. What is relevant is the
yes,
second one, because second one deals with,
yes, yes.
isn't it? Because the first one, he only says something, but all what has been mentioned in the first one is also mentioned in second one.
Yes.
And apart from that, the petitioner's case is also.
And we have challenged 36 because we have said that this order cannot be prospective in effect. For that reason also.
So that order is the
yes,
second
same,
one.
same, contents is same.
No, content is not same. The
uh,
second one is
Specifically against me.
to you.
Yes.
First one has no relevance to you.
As your lord.
Clear. Another. While the said representation was kept pending,
Let's please.
the board of directors of the respondent corporation in its 261st meeting held on 26/8/2023 decided to continue the existing service link advancement scheme for the employees of AIDC Limited, which was introduced with effect from 21/9/2001 with the approval of the board of directors of the respondent corporation in its meeting held on 1/9/2001. However, the said continuation with the said scheme was subject to certain partial modifications on account of signing of the MOU by the corporation, respondent corporation, with the government of Assam, and adopting the revision of pay scale and other allowances as per the Assam Service ROP Rules 2010.
Your lordship has put me a query regarding the revised pay scale that your lordship will find at page 41 in paragraph number 7 of my presentation. I have given that scale.
The modifications which were sought for, which were made to the service linked advancement scheme, where number one, that an employee who will be considered for upgradation under the service linked advancement scheme will be entitled for financial upgradation to the next higher grade pay only. Number two, as there was no individual pay scale like pre-revised pay scales for each category of post, rather only pay band with grade pay applicable, the benefit granted to the next higher pay scale should be modified as per the higher grade pay in the approved pay band / pay structure. Number 3. Taking into account that the AIDC, the respondent corporation, had not adopted the pre-revised scale of pay of rupees 10,375-16-050, which was revised to the pay band of rupees 12,000-40,000 plus grade pay of rupees 7,600, the board henceforth adopted that this pay scale oblique pay band to grant benefit under the service linked advancement scheme to eligible employees who are in the revised pay band of rupees 12,000-40,000 plus grade pay of rupees 7,400. Number 4, the board decided that the same principle for upgradation to the next higher grade pay will also be applicable to all employees who are in post oblique cadre of DGM in the pay band of rupees 12,000-40,000 plus grade pay of 7,400, that is, in respect of upgradation of eligible employees to the next higher grade pay under the service linked advancement scheme. Number 5, in case of promotion of the employees from the cadre oblique post of DGM in the pay band of rupees 12,000 plus 40,000 plus gate pay of rupees 7,400 or 7,600 to the post of general manager through public enterprises selection board, they would be entitled to the pay band of rupees 26,000-45,000 plus grade pay of rupees 8,700. In the later impugned order, which is of the same date, but bearing reference number AIDC oblique ESTT oblique 1 oblique T bracket T oblique 3310-19. The case of the petitioner was specifically taken, whereby the board approved the financial upgradation of the petitioner to the next higher grade pay of rupees 7,600. On the ground of the condition number 4 of the said office order. Therefore, from the said communication, said office order, which have been impugned in the instant proceeding, it transpired that the petitioner was put in the pay band of rupees 12,000 plus 40,000 with grade pay of rupees 7,400, which was thereupon, and thereupon the petitioner, on account of the slash, was granted the benefit to the next higher grade pay of rupees 7,600. Isn't it?
Yeah, ROP loads. It is page 93 load. This was given on the basis of the ROP, which was the memorandum of understanding was signed between the.
Understood. But this is the what you have stated out here, isn't it? So you have put her in the bracket of rupees 12,000 to 40,000 with grade pay of 7,400, and thereby increased the, on account of slash, you gave her the benefit of 7,600. That's it.
Payment for maximum benefit.
Understood.
Yes.
So you give 7,600. The petitioner being aggrieved on the basis of being only enhanced the grade pay of rupees 7,600 from 7,400. Submitted a representation on 29/2013. Claiming that the petitioner ought to have been granted the benefit to the next higher pay band, that is pay band 5, that is rupees 2,000, 26,000, there's 45,000 with grade pay of rupees 8,700. And not a higher grade pay of rupees 7,600 from 7,400. Inasmuch as the same was not conceived of in the ROP. Isn't it, Mr.
Yes,
That is your specific case?
yes.
The petitioner thereupon submitted various representations. However, as nothing but however, as no effective steps for redressal was taken, the petitioner was compelled to file the instant writ petition seeking the relief as already above mentioned. The record reveals that this court, by an order dated 18/12/2015, issued notice on 14th of March 2016. The respondent number 4 and 5 had filed a joint affidavit stating inter alia that the petitioner has been promoted to the post of company secretary grade 1, that is the top position in the cadre of company secretary. And there is no other post for promotion to the company secretary. The facts pertaining to the promotions which have been granted, to the petitioner, the facts pertaining to the appointment of the petitioner, the promotion which was being granted, the redesignation of a post, as stated in the writ petition, have not been denied. It was mentioned that the corporation, respondent corporation, signed a memorandum of understanding with the government of Assam on 2012. On the basis of the said MOU, the government of Assam allowed the corporation, respondent corporation, to adopt the provisions regarding the revision of pay scales and allowances, etc., as prescribed for the state government employees as per the Assam Service ROP Rules 2010, read with the notification dated 19/2/2001, with its own resources and to implement the same. It is interesting to note two clauses of the said MOU, which have in fact been incorporated in the affidavit in opposition. That is clause number 2 and 3. The clause number 2 related to that the corporation shall not create any new post without the prior approval of the finance department, to the industries and commerce department administrative department of the government of Assam. And as per clause number 3, any change or revision in the pay scale, allowances, perks, or any other service conditions of the Assam of the respondent corporation employee having financial implications and which is not as per the provisions of the Assam Service ROP Rules 2010 shall not be made without prior approval of the finance department. It was therefore the specific stand of the respondent corporation in their affidavit that in view of the signing of the MOU, the respondent corporation was bound to follow the Assam Service ROP Rules 2010, as well as the Assured Career Progression Scheme in regards to pay, allowances, etc. And accordingly, the corporation adopted the pay structure approved by the government of Assam for the SLP of Assam. What is this SLP? State level public enterprise.
Yes.
Bracket of state level public enterprise of Assam. It was also stated that the petitioner's earlier revised pay scale of rupees 10,050-15,575 was converted to the corresponding pay band 4 of rupees 12,000-40,000 plus rate pay of rupees 7,400. It was further mentioned that on 13/9/2013, pursuant to the decision taken by the Board of Directors in its 21st meeting, the Service Link Advancement Scheme was modified as stated in the affidavit. It was also mentioned that the petitioner had submitted various representations which was referred to the finance department of the government of Assam through the administrative department for a decision on the matter. It was further stated that the petitioner's representations did not entitle to and did not merit any consideration. More so, taking into account that the petitioner sought for creation of a new post, that is, conversion of a new post. That is the post of general manager, personnel and administration to company secretary, general manager level, which was not permissible. To the affidavit in opposition, an affidavit in reply was filed by the petitioner. Retreating her statements in the affidavit in opposition, in the writ petition. And further stating, on the basis of Annexure 3 to the said affidavit in reply, that there was no post with a payment for of 12,400, 12,000, that's 40,000 with rate pay of 7,600. It was therefore the specific case of the petitioner in the affidavit in reply that this imaginary payment for of great pay of rupees 7,600 have been only created to victimize the petitioner. Isn't it, Mr.
Yes.
That's your specific,
Yes,
sir.
yes. It's alien. It's alien to the ROP. And say that it has to be against a particular code.
Which
Of course, that has been pointed out by my lord in the first day itself. We picked it up on the property.
It is also relevant to take note of that in addition to the above pleadings, there are various other additional affidavits filed by the petitioner. My goodness, how much affidavit you have filed?
Just to prolong it from 2004.
Eh?
Just to prolong the matter, my lord, they will come out with a
You
new
have
date.
you have filed five additional affidavits. Let me come back.
It doesn't give never sign. It did. Oh. Followed by yeah. So they can add chat. Six as 6 1. Six as 3. Juliet.
In the first additional affidavit filed on 24/1/2020, the petitioner brought on record a communication dated 2011/2019 issued by the Industries Department and Commerce Department of the Government of Assam. Whereby the managing director of the respondent corporation was directed to inform as to whether the circular, whether the office order dated 13/9/2013 and the circular dated 21/9/2001 were adopted in consultation with the Industries and Commerce Department, Public Finance Department for further examination. This was done so in view of the representation submitted by the petitioner seeking review of the office order dated 13/9/2013. Thereby granting her the benefit with effect from 1/1/2013. This communication was followed by another communication dated 8/1/2015 by the Industries Department to the Managing Director of the Respondent Corporation to resubmit the proposal with the information as to whether the outflow of funds towards the salaries of the working company secretary happens from the budgetary support or not. In addition to that, the Industry Department further sought the views of the Managing Director of the Respondent Corporation by another communication dated 5/5/2018 on the representations so submitted by the petitioner. The second additional affidavit dated 25/1/11/2021 was filed to bring on record the extracts of the minutes of the 303rd AID Respondent Corporation Board's meeting held on 30 October 2021. As well as another representation submitted by the petitioner on 16/11/2021. The said documents, the said board's meeting, minutes of the board's meeting held on 30/10/2021 was brought to on record to apprise this court that the Respondent Corporation, without seeking the concurrence or decision of the government, had adopted the said resolution whereas the respondents claim under the service link advancement scheme was referred to the government by the board for the decision. The third additional affidavit was filed on 22/12/2021 by the petitioner. To draw to the attention of this court that the petitioner was issued a show cause notice on 16/12/2021 alleging misconduct, and the petitioner's written statement cum written explanation. The fourth additional affidavit was filed on 25/3/2022. Whereby, in order to bring to the attention of this court another show cause notice on 21/12/2021 and the written statement, public statement of application, explanation. So submitted. The fifth additional affidavit was filed on 25/4/2023. Which was in pursuance to the order passed by this court on 30/3/2023. Thereby, whereby this court directed the parties to obtain instruction / information regarding two specific queries. The first pertained to whether the AIDC was bound in terms with the memorandum of understanding entered into with the government of Assam even prior to its adoption on 13/9/2013. To be bound by the Assam Service Revision of Pay Rules 2010. And the second query pertained to whether during the period from the date of entering into the memorandum of understanding by the AIDC with the government of Assam till 13/9/2013, there was any financial upgradation given to those officers holding the rank of Deputy General Manager in terms with clause A of the /SLA. By way of the said affidavit, the petitioner stated in respect to the query number 1, that the MOU entered by the AITC with the government of Assam on 24/9/2012 creates a binding obligation on the AITC from the date of signing of the MOU. As regards the second query, it was mentioned that after entering into the MOU on 24/9/2012, in the 256 board's meeting of the respondent corporation held on 29/9/2012, approval was granted for payment of the revised pay scale to all employees of the corporation as per the ROP rules 2010 with effect from 1/10/2008 in consonance with the provisions applicable to the state government employees. It is further relevant to take note of that in pursuance to the query made by this court on 30/3/2023, an additional affidavit was filed by the respondent number 5 and 6. Stating inter alia that on 12/9/2012, the corporation had signed an MOU with the government of Assam, after which the corporation became bound to follow the Assam Service ROP Rules 2010 of the government of Assam, as well as the ACPS in regard to pay for my allowances, etc. Clauses 2 and 3 of the MOU dated 12/9/2012, which have been already mentioned in the original affidavit in opposition, was reiterated. Further to that, the reason why the pay band for highest pay band 4 of 12,000 dash 40,000 with grade pay of 7,600 was adopted was stated in the said additional affidavit. The allegations so made in the writ petition as well as the various additional affidavits of the petitioners have been denied. Mr. Goswami, what is this at page 243? What is this document?
What is 43 lordship? The pay bench.
When did you make it?
Okay.
When did you make that?
It is the
Huh? This pay band, when did you make it?
it was in my earlier affidavit also.
Understood. When did you make it? This is only after 13.9.
Yes.
Because 13.9 only adopted this.
Yes.
Not earlier. To the said additional affidavit, various documents have been enclosed. That is, the circular dated 21/9/2001, the Assured Career Progression Scheme of the Government of Assam dated 25/5/2011, the Memorandum of Understanding between the government and the government of Assam and the respondent corporation. Where's that? Where? And the revised pay structure. Before continuing, this court finds it very pertinent to observe that this court had put a specific query upon Mr. J.K. Goswami, the learned counsel appearing on behalf of the respondent corporation, as to when the revised pay structure was made. He submitted that the same was done pursuant to the office order dated 13/9/2013. In the backdrop of the above pleadings, let this court now consider certain other developments which took place while hearing the instant proceedings from time to time. Pursuant to the query made on 33/2023, as noted above, the last of the two additional affidavits have been filed, one on behalf of the petitioner and other by the respondent corporation. Thereupon, when the matter was listed on 4/1/2024, the counsel appearing on behalf of the respondent corporation submitted that the proposal for consideration of the representation submitted by the petitioner have been lying before the Industries and Commerce Department as well as before the Finance Department. Under such circumstances, this court sought the instructions from both the Finance Department and the Industries Department as regards the status of the proposals, if any, submitted by the AIDC to the said departments. On 13/2/2024, the Standing Council of the Industries and Commerce Department of the Government of India submitted that on 12/2/2024, a communication has been issued to the Managing Director of the AIDC for submission of certain papers within 3 days from the date of the said letter, so that the matter could be taken up by the Industrial and Commerce Department at the earliest. The counsel appearing on behalf of the respondent corporation undertook on behalf of the respondent corporation to do the needful at the earliest. Thereupon, the matter has been listed today. During the course of the hearing, Mr. J.K. Goswami had submitted certain documents accompanying his written arguments. The first document pertains to a communication dated 17/2/2024 issued by the Managing Director to the Director (PE) Industries, Commerce and Public Enterprises Department. In the said communication, the gist of the case have been mentioned. And in addition to that, at paragraph number 4 of the said communication, it was mentioned that the petitioner was in the habit of filing various cases of representations against the corporation. And it was specifically mentioned that the corporation had issued a letter on 21/1/2020 informing the petitioner that as the matter is sub judice, her representation shall be considered for a decision only after the judgment of this court. It was further stated in the said communication dated 17/2/2024 by the Managing Director of the respondent corporation that the said proposal was submitted on behalf of the petitioner. The said proposal was submitted of the petitioner for review of the office order dated 13/9/2013 and to upgrade her as per the SLAs with effect from 1/1/2013 for referring the matter to the Finance Department, Government of Assam for a suitable decision with your views. It further reveals that the Director, PE, Industries and Commerce and Public Enterprise Department had written a communication to the petitioner informing that the matter was earlier consulted with the Finance Department and the Finance Department in its views dated 17/10/2019 submitted that the ACPS/MACPS is for regular state government employees. And the Finance Department is not in a position to offer any views on the state service-linked advancement scheme, which is not under their purview. The MACP/ACPS does not extend to the employees of AIDC. As such, the administrative department may be advised to take its own decision. It was therefore informed that the Industries, Commerce and PE Department was in agreement with the stand taken by AIDC in the writ petition and the matters to dispose and to dispose of the matter accordingly. The effect of the said submission, said communication, dated 4/3/2024, shows that the Industries Department is in the views of the Industries Department aligns with the view of the respondent corporation in its stand. Isn't it? In its stand taken in the instant proceedings. Mr. Gutami, did you bring on record the rejection of the petitioner's claim for financial upgradation on 12/1/2011? First of all, as on that day, the petitioner was not entitled. The question of taking that has no relevance. Here, his entitlement is only from 31/12/2002. 12. You adopted or you brought in this new pay scale
On 11.
on 13/9/2013. Isn't it? Because earlier, obviously, she was not entitled to slash.
Lordship and the MO, page 39, 93, 93. It was signed on 12/9/2012. And the pay structures approved by the government of Assam for SLPS of Assam is with effect applicable with effect from 1/1/2011.
Which one?
Yeah, this one, page 94 in my
94 of?
94 of my affidavit in reply.
No, don't give
affidavit
that.
in
Running
opposition.
page. Running page.
94.
9.
It's 94.
Ah. Yes.
Pay structure approved by the government of Assam. It's applicable with effect from 1/1/2011. That is it.
Government of Assam has allowed the demand to adopt the provision of demand only to implement the same with government of the government.
Well, government has approved in page 94 on 19/2/2011, but it was in their-
12/9/2012.
Yes, we are no applicable with effect from 1/1/2011, page 94.
Yes,
Understood.
Right. But
whatever may be, but it was done on 12/9/2012.
yes, but it was adopted by AITC in their affidavit. They have stated para 11 at page 226, or that is from 13/9/2013.
No. 13/9/2013 is there, but
Yes.
12/9/2012 was the date on which this pay scale has come into being.
Yes.
Yes.
If that be so, your entitlement
It's
for a
that.
hire would only arise on 13/12.
But this was not adopted by AITC.
AITC has signed it.
Memorandum.
No.
When the memorandum is being signed by the AITC, what is the AITC has to adopt or not?
No. Your lordship will kindly see page 226, para 11. But prior to that, your lordship will see page 93. I'm sorry. Prior to that, your lordship will see page 93.
Yes.
Government of Assam by Finance Department notification dated 24 has allowed the Assam Industrial Development Corporation to adopt the provision regarding revision. This adoption was done on 26/8/2013 by its 261st board meeting, and that is reflected in page number 206 and 207. The language is
That was on
26/8/2013. That is 261st board meeting, and that is reflected in page number 206 and 207. So this, unless it is adopted, it will not be applicable. It's clear from it. Has allowed the Assam Industrial Development to adopt the provision. So this adoption was done in the 261st board meeting. And
now, are you going to get the amount? Did you get the amount of 12,000 to 40,000 with 7,600 with effect from 1/1/111?
No, I got it from 13/9/2013.
No, it can't be. It has to be from 1/9.
Yes.
It can't be from. It has to be from that
No,
date,
your
on the
lordship
date
will
on which was adopted.
Yes. Your lordship will see the impugn order at page 36.
Impugn order was passed subsequently, stating that
So,
in view of the 261th meeting out there, these are the new conditions which have been set out, which have been brought on.
Yes. Page 36, your lordship will see the line.
It is only if you don't have a higher grade pay, then only you can go to the next payment.
Yes.
But if you have a higher grade pay, you will go to the next higher grade.
But this grade pay was completely alien to AITC because your lordship has day one, your lordship has pointed out that any grade pay has to be in respect of a particular post. That is the ROP 2010. There is no post against this grade pay of 7,000. It was only They have not even adopted the assured career progression. They have come up with their own slash modified. It's a modified. Your Lordship has rightly pointed. Your Lordship will kindly look into this ACP and ACS scheme has been discussed by the Honorable Supreme Court in one of the judgments. Your Lordship will kindly take note of it. It will be a guiding factor. And earlier we had given a citation based on stagnation of service. I
understood, but this stagnation will be only on a grade pay, unless there is no grade pay.
So grade pay again, my lord, in one of the judgment.
You cannot jump beyond that.
Yes, yes.
If it is, just for example, you were in 7,200. Let us example. If there is 7,400 at that point of time, then you will be going to the next grade pay of 7,400. But beyond 7,400, there is no grade pay available. Then you go to the next pay band. That's it.
Yes, yes. And grade pay is again not applicable to the scheme, and again clarified in one of the judgment of the Supreme Court. That's what I was. But even then, your Lordship will kindly see this judgment, paragraph number 12.
Yes.
It may be worth noting that the ACP scheme was enforced on the next 13. At the cost of repetition, it must be borne in mind that the object of ACP is to avoid stagnation where no promotional avenues are available. The grant of ACP is not technically a grant of promotion, but increase in the pay scale to the next higher grade, retaining the employee on the post held by him. This is only to accord monetary benefit without disturbing any seniority or actually effecting promotion to any higher post to avoid stagnation on a particular post or pay scale for a very long period. The objective purpose of ACP MSCP scheme has been reiterated by this court in Union of India versus C.R. Madhava Murthy, 2022 6 SCC 183, as one to relieve the frustration on account of stagnation, and it does not involve actual grant of promotional post, but merely monetary benefits in the form of next higher grade, subject to fulfillment of qualification and eligibility criteria. In sum and substance, both ACP and MSCP schemes are schemes devised with the object of ensuring that the employees who are unable to avail of adequate promotional opportunities get some relief in the form of financial benefit. Accordingly, the scheme provides for regular financial upgradation on completion of 12, 24 years and 10, 20, 30 years of service without promotion. They are incentive scheme for the employees who complete a particular period of service but without getting promoted for lack of promotional avenue. The effect of the scheme must be just keeping in view the object and the purpose of the scheme. In Union of India versus G. Ranjana reported in 2008, 14 SCC 721, the three judges bench of this court held that in situ promotions are made to remove stagnation of grade C and grade D employees by giving them certain monetary benefits. It was further observed that fulfillment of educational qualification prescribed under the recruitment rules for the purpose of promotion are not necessary for non-functional in situ promotion. In other words, educational qualification required for the purpose of promotion is not necessary.
Now tell me one thing, Mr. Gustami. Now, what is the present status?
Yes, sir.
Because she was in the final one, huh?
Lord,
She was in the final grade pay.
Lord,
Now what has happened?
Lordship,
Now to 10 years have gone back
Lordship,
from 2012.
Lordship, she obtained the highest pay from her level.
Now understood.
Lordship,
Thereafter, you cannot stop. She's entitled to the next higher pay band.
Lordship, Lordship, there are Lordship in entire career, Lordship, that pay band, Lordship, that pay band is it is for general manager. Next pay band is for general manager.
Understood. Whatever may be, as of now, 10 years have already passed.
But only Lordship,
She may not be entitled to at that point of time because 7,600 was the highest grade.
Look.
Thereafter, there is no highest grade pay.
Yes.
Above that. Then what happens to these 10 years then? Because that is another post question arises as regards the last third one. The first two, yes, court may not interfere with the impugn orders, saying that this creation of 13.9 was okay because it was in terms of the MOU, it's okay. And at that point of time was there when she did not qualify at that point of time. She only qualified on 13/12/2012. Okay. But after qualifying that she is now the company secretary, got the grade pay from 1/1/2013. That is as per you. If she has got that 10 years have now passed, how do you take care of that now? But she's now entitled to. She may not be entitled to for other aspects. But how do you wouldn't she now be entitled for the next 10 years after 10? Can you deprive her? Unless there is a great pay.
Lordship, regarding slash, regarding slash, now ROP is adopted, Lordship. And therefore, on the basis of the ROP,
Is there any other higher grade pay now?
Lordship, regarding this higher grade, it means next post is general manager only.
Understood. So there is nothing.
No.
So wouldn't now she be entitled to the higher grade payment from 2015? From 2020? Because on the last prayer which is being made for creation, there I can give her from 2023.
Your Lordship will kindly look at page 36 again.
Huh?
Page 36 again. The paragraph number 3. From that, the first query will be clear. Page 36. Page 36, where paragraph number 3. As AIDC has not adopted the pre-revised scales of pay of so-and-so, which has been revised to pay band of so-and-so, plus grade pay of rupees 7,600. Henceforth, the board adopted this pay scale pay band to grant the benefit under the service link advancement scheme to the eligible employees who are in the revised pay band of so-and-so, so-and-so, and so-and-so. Means that the employees up to the revised GGM will be granted the grade pay of rupees 7,000 under slash. Now, if your Lordship reads the affidavit filed by the AIDC, it will make no sense as per their contention is concerned that your Lordship will look at page number 226. 226.
Yeah.
Page 226, that internal page is 11. Although the service link advancement scheme came into force on 2001, but after signing of MOU with Government of Assam, the corporation is bound to follow the state government rule as well as assured career progression scheme, which resulted in amendment of slash with effect.
No. Those have no relevance. We are not concerned with those, with the ACP and all. But the only question is, Mr. Goswami, as of now, there being no higher thing, there no higher grade pay, then wouldn't she now be from 2023 be entitled from 1/1/2023 because the case is pending?
Now that this scheme will not cover all the employees. This scheme will cover all the employees of the corporation except the Public Enterprises Selection Board post PESB. This is the general manager and above.
Understood, not necessary. Whether she will not be entitled to the grade pay. Because that would amount to stagnation. And more particularly when it is your admitted stand that you follow the MACP and SCP.
That will come
Now it is 10 years, 10 years.
Yes.
So now you are bound. Isn't it your specific stand out here? You can't backtrack that. Too many pleadings have gone by.
And well, since 2013 also she is under stagnation.
No, understood. That is
2013.
That is what I am trying. Mr.
Lordship, these are the pay pens. Pay pens, he may be restrained with the particular pay pen. He may not extend next pay pen. Next pay pen is for the general manager only.
Can't help it. Therefore, if there is no great pay, can there be a question of stagnation? Shouldn't it be a pure and simple case of stagnation? And that too, when you follow what is SCP and MACP.
Lordship, I have some instruction, Lordship. one comparison I compared to other DGM lordship along with the petitioner lordship, it appears that the petitioner getting higher than others.
I'm not concerned with all those things. I'm simple concerned with what the next payment she is entitled to. Because of the fact that there is no after 7,600.
Yes.
Then
She will
why she would not be entitled with effect from 1/1/2023? She may be not entitled to there because you created the additional grade pay at that point of time. But why not now?
No, payment 5 will come.
Yes, payment 5 she will come under payment 5.
Payment 5 is for the general manager.
So what?
It is the public enterprises post lordship for that
Understood,
lordship.
whatever may be. Mr. Goswami,
Yes.
whatever may be.
For that lordship, I have to take the prior approval from the finance department.
You do whatever you like. I'm not concerned. This is the mandamus directing you to give.
Here,
We are not
it
concerned
is,
with
it is
whether
clear
you
from
will
the-
take the approval or not. Their approval was only as regard that, the finance department. You are not creating a post. Kindly see. Your MOU with the department, kindly come to page 92 again. Your MOU with the department,
Yeah, 93. Page 93. Let's
your MOU with the department categorically says that any change or revision in the pay scale, allowance, parks, or any other service conditions of so-and-so employees having financial interest which is not as per the provisions of so-and-so shall be made without prior approval of the finance department. If it is not in consonance. But as per you, the next is the higher is the year. And your basic case is you follow ACP, MECP. All along you have been stating. So 10, another 10 years, she will get the next higher rate pay above the general manager. What happens to a general manager if he has 10 years?
General manager, lordship, lordship, here another point is there, lordship. What is that, lordship? This SCPA is not applicable for the public enterprises post, which is required for above the general regarding the general manager, lordship. Post of the general manager, this policy is not applicable. Here,
No, I'm not concerned with that. I'm concerned with it. Kindly see the ACPS out here. What is the use all along say that how the ACPS is. In case a person, kindly see here, page 241.
lordship, in it page 30, lordship.
No, don't come back.
So since 2013, I have been given 3% increment, and this year no increment, and half increment last year. So I have again stagnated every. From 2013, they have only given me a 3% increment. As per
No,
government
where is
policy.
it that once you complete, you are in the highest grade pay of a payment, then the next ACP or MACP, if it is taken, it will go to the next payment. Where is it? Where is it? Okay, in the paper.
Well, that distinction between ACP and MACP.
Because what I understand from grade pay is this. Grade pay is nothing else. The simple aspect
is
that whenever there is a increment means increments or whatever may be, the DA is being calculated. Then in that regard, because of this grade pay, otherwise the concept of grade pay was brought in only on the basis that earlier what happens, these employers said, look here, our department is not doing well, we are not going to pay you. So in order to protect this increase, this grade pay business has been brought in. And thereby, whenever there is an increase, your next increase will be 7, or the increment which is being given will be given 7,600. This is how the DAs are calculated. So this is how you have the grade pay for your purpose.
Your Lordship will kindly look into this discussion and findings at paragraph number 28 in regard to, it may throw some light matter. Paragraph number 28 at page 438, discussion and finding. Though various contentions have been raised assailing the MSP scheme, namely financial arbitration in the next grade pay, and no stepping up of pay on the ground that junior getting more pay, be it noted that clauses of the MSP scheme, including the clause providing the financial arbitration in the next grade pay, have not been challenged so and so, and not gone into so. As pointed out earlier, that paragraph 29, both ACP and MSP schemes are in the nature of incentive scheme devised with the object of ensuring that the employees who are unable to avail of adequate promotional opportunity get some relief from stagnation in the form of financial benefit. Under the MSP scheme, financial upgradation are granted at 3 regular intervals or completion of 10, 20, 30 years of service without promotion. Hence, it is also intended to ensure that the employees are adequately incentivized to work efficiently despite not getting promotion for want of promotion. The change in policy brought about by superposition of the ACP scheme with the MSS scheme is after well-deliberate and well-documented recommendation of the 6th Pay Commission. Then that grade pay concept your Lordship will find in the next paragraph. The learned
Yes. Where?
Paragraph 30. The learned amicus curiae and the learned counsel appearing for the response asked the court to adopt a purposive interpretation that awards immediate next higher grade pay to be interpreted as grade pay of the next promotional post in the hierarchy. MSP schemes merely placement in the immediate next higher grade pay. By perusal of the MSP scheme, etc., it is seen that the words used in the scheme are placement in the immediate next higher grade pay in the hierarchy of the recommended revised pay. The term grade pay in the next promotional post is conspicuously absent in the entire body of the MSP scheme. The argument of the respondent that the benefit of the MSP scheme is referable to the promotional post is dehoys the MSP scheme and cannot be accepted. Though ACP and MSP schemes are intended to provide relief against stagnation, both the schemes have different features. Pay scales under the 6th Pay Commission and the MSP schemes are stated to be more beneficial since it extends to the employees with time intervals with higher pay bands at various facilities, which are not available under the ACP scheme, including the 3 financial upgradation in shorter time. In any event, MSP scheme has not been challenged so and so. The object behind the MSP scheme is to provide relief against this. If the arguments of the respondents are to be accepted, they would be entitled to be paid in accordance with the grade pay offered to a promotee, but yet not assume the responsibility of a promotee. So basically, as submitted on behalf of the union, if the employees are entitled to enjoy grade pay in the next promotional hierarchy without the commensurate responsibility as a matter, it would have an adverse impact on the efficiency of administration. This change in policy brought about by the superstition of the ACP scheme basically, my lord, this judgment focuses on the distinction between the ACP and the MSCP scheme. The earlier judgment which I have placed before your lordship, there they said that in situ promotion, since there is no post, but you will be given only the financial benefit. They use the word in situ promotion. So here I am not asking for the DGM post. This grade pay of 7,600 is created on 13/9/2013 only to deprive me. It was none.
No, not to deprive you. You submitted your submission application only on 30/12. You submitted your application first representation on 13/12/2012, stating that you are going to complete on 31/12/2012.
Yes.
Whereas the government and they have already entered into an agreement prior to that where grade pay of 7,600 was already there.
But it is subject to adoption, as your lordship has.
That's a different thing,
Yes.
but they have already, that is
Yes.
nothing to do against you.
Yes. Adoption is subsequent to our entitlement.
That has nothing to do.
Yes.
Only thing is here is that you will be entitled to, therefore, there being no other posts available. Subsequent thereto, there being no other grade pay available,
Yes.
then under such circumstances from 2023, you will be entitled to.
Lordship, in page 30, Lordship, this circular scope, the scheme will cover all the employees of the corporation except the Public Enterprises Selection Board post, PESB. This is the general manager and above. This scheme
That is
is
in
not
respect
applicable.
of technical post only.
This scheme is not applicable for the post of general manager and above. Now, Lordship, if suppose Lordship, a general manager, he completed all the payments, then will he promoted for the post of chairman?
No.
No, Lordship. And
He would not.
No, yes.
We are not concerned with the promotion, Mr. Counsel. Kindly appreciate. We are not concerned with the promotion. It is only for the removing the stagnation.
Yes. But regarding stagnation, Lordship, he got from the end. If your
Mr.
Lordship
Counsel, would you like out here that you always sit out here to do the matter and the authority standard for next 15 years only gives you 500 rupees as your fee?
No, Lordship, no, Lordship. But so far, Lordship,
That is called stagnation.
No, Lordship, Lordship, if she enter into the Lordship, so
I
far
don't know.
in the
Mr.
career,
Goswami, I don't know anything. The thing is, she will be entitled from 1/1/2023. Do whatever you can and find out a good reason out here. And give me a reason how I can give her the benefit. That is the only work you have. You don't have the work of opposing them. Don't come up with this opposition. You find out the reason. Yes, that is why I'm going to take the help of the third prayer, that she cannot be granted a promotion to that post. However, she has to be given because there is no other grade pay available. And as such, applying this is. So this part of the judgment I'll deliver again on 23rd in your presence, top of the list. Okay, any answer? That is the thing. I'm not going to give.
May I pray on 24th?
No. This is on Tuesday. This matter I have to spend a lot of time on. And you come up with a better ear. Don't come up with this opposition thing.
Lordship,
Something has to be done. A person fighting for all this.
Lordship.
25th will be inconvenient to your father. 25th is Thursday.
Huh?
25th Thursday.
Only thing I can do is to release it from part third. Whatever
them
has
late.
been done, I'll have to scrap it. I'll impose a cost of 2 lakhs upon you. That is
Let
the
it be on
only
20th.
thing.
My friend will say, yeah, I have some.
This is the order.
Yes.
This goes from 2000. This court would not say that there is a case of victimization because the great pay business was brought on 7,600 prior to your entitlement or your entitlement. So therefore, it cannot be said that it to be a case of victimization. But however, from 1/3/2023, she has completed 10 years. And as such, you will be entitled to this. So whatever needs, Mr. Gustami, you help it out. Whatever needs to be tweaked out there in the judgment, nothing more than that. That is my final outcome of the judgment. Now, nothing more. Second Ghurai, 23rd. You want it on 25th? You won't be there.
Yeah, because your lordship has concluded only, my friend can always be there.
You
Because I
bhai,
didn't want to disturb the redeem of the court.
No, there is no redeem. Redeem has already lost.
No.
It's already because on the last day of the working day of the Bihu, I am working till 4:30. It doesn't look like.
Yeah.
Other people will also. Taking him third party. 23rd. Are you able to say? Stop here.
When your lordship says 2 lakh cost, nobody will ask for 25th.
Eh?
When your lordship says 2 lakh cost, no, the council will ask for 25th.
No. Councils like you, there is no problem.
Right.
Other councils may have difficulties, not for you. I thought I was over. I didn't know that there was a hearing matter. I thought that today at 3 o'clock I'll be over.
Oh. Hello, second.